Majority respectively of each of the two groups of members present. I declare the motion negatived.
第四項
Fourth members motion, safeguarding the rule of law and judicial independence. Members who wish to speak in this motion debate will please press the request to speak button. I will now call upon the Honorable Dennis KWOK to speak and move the motion. The Honorable Dennis KWOK. Thank you, President. I move that the motion as printed on the agenda be passed. President. Perhaps there might be someone in this council who believes that the motion is unnecessary. They believe that the rule of law in Hong Kong is well and alive, and this motion is superfluous. However, Justice Buckley once warned us that a storm unprecedentedly fierce is waiting for us. When he retired from the CFA, he did not go with blessings, but he sounded a warning for us. This is rather unlucky and rather unusual. Unfortunately, what he predicted has just come true. Not long ago, the Ms. Elsie Leung, the previous S4J, referred to the previous Ng Ka-ling case. He said that there is a lack of proper understanding by the judiciary of the central Hong Kong-SAR relationship, and she is of the view the interpretation of the basic law would not affect the independence of judiciary, and there's been 4 occasions already since the handover, and therefore reinterpretation of the basic law has been accepted by our judiciary, and that our legal system can be changed. I think she has laid down what is to come, and we cannot regard her remarks as something ordinary. Article 19 of the Basic Law states that we enjoy, the SAR government enjoys independent judicial power, including that of final adjudication, and that the court in Hong Kong has the final adjudication for all cases within the limits of the basic law. And if interpretation of the basic law is to be raised by the government, that would deal a blow to our judiciary. And then the incumbent S4J also proposed that the court apply to the MPCSC to clarify the basic law on rights of abode case, and that they will not take the initiative to apply to the court, apply to the MPCSC for reinterpretation. I think they are hanging a sword right above the judiciary in Hong Kong, and ask them to be cooperative. Yes, these are very controversial issues, but has the administration considered that interpretation of the basic law by the MPCSC is a very controversial issue as well, and it will undermine our judicial system, which has been long established, and this is a threat to the separation of powers in Hong Kong. The separation of powers is one of the pillars of success of Hong Kong. There are checks and balances among the 3 powers, and the rule of law will ensure that justice is done to everybody in Hong Kong. However, the administration lacks popularity. It doesn't have any mandate and credibility. LegCo, it has been increasingly difficult for LegCo to monitor the executive, and the judiciary is it's a last photo, and if it is undermined, it will be a major problem. Some would say that we're just scaremongering. However, the rule of law is what makes Hong Kong tick under the one country, two system notion, and has helped us to get the trust of the people. Without the rule of law, well, we can't have any justice in the economic and social front. On the economic and social front, the storm is coming. We must not take this lightly. We have a sense of what is coming. We urge the public to stand on the same front with the legal sector and let's withstand the storm so that we can have a stronger system.
It is said that the price of freedom is constant vigilance. I say it is also the very price that we must pay to safeguard the rule of law today. Mr. Justice Buckley warned of an impending storm for the rule of law in Hong Kong. In light of the recent developments, I'm sad to say that the verification of his prophecy is now painfully self-evident. 15 years after the handover, it is time for us to remind ourselves in this very chamber the cardinal principles of the rule of law, the common law tradition, the rules of natural justice and procedural fairness, due process, habeas corpus, an independent judiciary, access to court for all, and an independent legal profession. President, therein lay the foundations of the legal system we have, and I dare say, of the fundamental pillar under one country, two systems, under the basic law. These very principles form the bright constellation which has gone before us and guided our steps through an age of transition and reformation. The Hong Kong people helped founded this special administrative region. We've helped crafted a constitution known as the Basic Law. And in this constitution came the powers that were bestowed on our government. We've made it an executive government subject to checks and balances. We've defined its authority. We've restrained it to the exercise of such powers as are granted to it by the law. And we've not stopped there. Who then shall construe this grant of power under the Constitution? Who shall interpret this Constitution? With whom do we repose this right of deciding on the powers of government? Are we at the complete mercy of state discretion and state construction of our Constitution? President, if we are, then in vain will be our attempt to maintain and protect our Constitution. In the Constitution itself, a proper and suitable mode of tribunal for settling questions of law have been established. Article 19 of the Basic Law states, the Hong Kong Special Administrative Region shall be vested with independent judicial power, including that of final adjudication. Apart from cases involving acts of state, defense, and foreign affairs, our courts have jurisdiction over all cases, and that their judgment shall be final. The Constitution has itself pointed out, ordained, and established the authority of our courts. The rule of law and democracy must go hand in hand. For democracy may disarm an oligarchy, a privileged class, but it can still crush individuals as merciless as any dictator can if we live without the rule of law. The rule of law is what makes Hong Kong shine as the gem under one country, two systems. The rule of law is what makes our nation not only great, but shall transform it into a good and moral one. Our present course is to protect and treasure the rule of law in Hong Kong so that when the national impetus for change arrives, what we have in Hong Kong shall shine in the rest of our nation. This is the very task set upon us. Let us look into our country and our cause and elevate ourselves to the dignity of pure and disinterested patriots and drive our country towards that of a just and peaceful nation. I know that there are many who believe that the time is gone when one can appeal to those high and honest impulses that were once the mainstay and the element of our character. Yet I believe it is a noble thing to have the opportunity to guide the development of our nation and to influence the destinies of our people. If ever it was an object of honorable ambition, more than ever must this be so at the moment which we are speaking. This is an hour when the foundation of the rule of law is under threat from those who disagree with its basic premise. They are the enemies of the rule of law, and they represent the powerful forces that threaten what we hold most dear to our hearts. They are the soulless men who believe in nothing except the brutality of power alone without constitutional restraint. Whether this threat is real or imagined, as some would blindly try to argue today, we must nevertheless safeguard the rule of law with all our might and with all our strength, President. For history shall blame us for our false sense of complacency should we allow the rule of law to fade, to slip away, and to leave its foundations broken and unrepaired whilst under our guard. We must continue to provide ample resources to support the work of our judiciary and judges, to protect their status, to safeguard their independent judicial role. We must ensure access to justice for all, irrespective of one's economic condition, hence the need to continue to expand both civil and criminal legal aid. Justice ought to extend her protection with rigid impartiality to the rich and to the poor, to the powerful and to the humble. And likewise, the independence of our legal profession must also be guarded against any infiltration. A healthy and independent legal profession is key to maintaining the rule of law in Hong Kong. President, There are politicians in this council, men and women, who have looked with ambition to the honors of high public office. These are the same men who have now been pressed into a groove from which they can neither escape nor retreat, holding high public office but maintain there at the expense of their present convictions, which do not harmonize well with their earlier opinions under a different role. May I remind those that the rule of law does not change depending on one's role or standpoint. The principles of rule of law do not change no matter where one is stationed in life. Be you now speaking as the chairman of the bar, the secretary for justice, a member of the legal profession, or an ordinary citizen seeking a day in court. No, the impartial and fair scales of justice do not change. President, I contemplate the progress of the rule of law in this nation will be slow and painful, but I look forward to it with perfect composure and confidence. For establishing the rule of law for our nation begins with upholding our Constitution here at home by means of an independent judiciary and from a conviction of its benefit that will accrue to the great body of the people in this nation. I move this council to support the motion. Thank you, President.
現在各位提出嘅待議。
I now put a question to you, and that is the motion moved by the Honourable Dennis KWOK be passed. Dr. LO Wai-kwok, Mr. Kwok-him, and Mr. Gary Fan wish to move amendments to this motion, while Mr. Tam Yiu-chung wishes to move an amendment to Dr. LO Wai-kwok's amendment. This council will now proceed to a joint debate on the motion and the amendments. I will now call upon the above members to speak in the above order, but they may not move the amendments at this stage. Dr. LO Wai-kwok.
Mr. President, the original wordings of the motion is the rule of law, the legal system, and the judicial independence are all commonly recognized, generally recognized in Hong Kong. And since 1997, the reunification of Hong Kong to the mainland, it is generally recognized that we have a high autonomy of rule of law and judicial independence. My amendment to the motion is that it has to be done in accordance with the principle of one country, two systems and the provisions of the basic law. When we uphold the rule of law, the legal system and judicial independence in Hong Kong, everything has to be taken against this actual situation of Hong Kong. Mr. Tam Yiu-chung and Mr. IP Kwok-him added the word continue to place emphasis on continue to uphold one country, two systems. I do not oppose to that. The word one country, two systems is well known to Hong Kong people, and you often heard it spoken. But what is the relationship between one country and two systems? Not many people can make it out, because given reality, this is a very complicated issue. I think that there should be a comprehensive and objective understanding of one country, two systems. One country, two systems is an intertwined concept. One country is the foundation, and two systems stem from it, because the basic law is authorized by the China Constitution and also the NPCSC. One country, two systems should be compatible, and we should have the relationship. We should have a proper relationship between central government and the Hong Kong SAR, so that we can accommodate the difference of the two systems under one country. One country, two systems are fully materialized in the basic law. Since 1997, the basic law became Hong Kong's mini constitution. It is the first society run on the principles of one country, two systems. So we should have an objective and comprehensive understanding of the basic law. And under Article 2 of the Basic Law, the NPCSC The National People's Congress authorizes the Hong Kong SARG to exercise high degree of autonomy and enjoy executive, legislative, and independent judicial power, including that of final adjudication in accordance with the provisions of this law. A lot of legal scholars emphasize the word of authorize because it clearly clarifies the relationship between the central government, NPC, and Hong Kong SARG. Some people think that a high degree of autonomy means complete autonomy. I think that if it is done in accordance with the one country, two system principle and the provisions of the basic law, can we fully understand the spirit of the basic law and also issues related to the rule of law, legal system, and judicial independence. The concept of independent judicial independence are fully realized in the basic law. They are Articles 2, 19, and 89. That is, the court in Hong Kong will have final adjudication, and when doing their work, judges will not be subject to any intervention. And of course, in any jurisdiction, the power of the judiciary is not unfettered. And Article 158 states that the power of interpretation of this law shall be vested in the NPCSC. It also says that the courts of the Hong Kong SARG may also interpret other provisions of this law in adjudicating cases. And under Article 158, it also says that the NPCSC authorizes the courts of the Hong Kong SARG to interpret on their own in adjudicated cases the provisions of this law, which are within the limits of the autonomy of the region. However, if the courts of the region in adjudicating cases need to interpret the provisions of this law concerning affairs which are a responsibility of the central people's government or concerning the relationship between the central authorities and the region, and if such interpretation will affect the judgment on the cases, the courts of the region shall, before making their final judgments which are not appealable, seek an interpretation of the relevant provisions from the NPCSC through the CFA. When the Standing Commission makes an interpretation of the provisions, the court of the region in applying those provisions shall follow the interpretation of the Standing Committee. However, judgments previously rendered shall not be affected. This shows that the basic law has dealt with the rule of law and legal system and judicial independence in Hong Kong. It has also clarified the power of the CFA and the NPCSC. And therefore, it is part of the legal system for the CFA to seek interpretation from the NPCSC. And since the reunification, there are 4 occasions when interpretation was sought, and they have been done under valid grounds. And the interpretations have not affected the daily operation of our legal system. In litigations, the courts apply basic provisions of the basic law and other provisions, and that has not been undermined. So under the basic law, subject to specific conditions, interpretations may be sought from the NPCSC. This should not be seen as damaging our legal system and the judicial independence. So when we deal with rule of law, legal system, and judicial independence, we need to have a full understanding of the principles of the one country, two systems, and also the provisions of the basic law, so that we will not be blinded. I fully understand with some analysis of local legal scholars and academics. They think that the challenges faced by Hong Kong courts is, on one hand, how to continue the rule of law and the legal system and judicial independence, and they will have to avoid overly politicizing the role of the courts, because they are there to deal with legal issues. The basic law is our mini constitution, and in order to preserve its stability and solemnity, we have to be very cautious when dealing with issues related to the basic law. We should not resort to expedient measures. I cannot agree with Mr. Gary Fan's amendment, because if we amend the basic law to resolve the problems of babies born to women with pregnant women with no Hong Kong ties, then next occasion we will have another reason to amend the basic law, and it will never end. And Article 159 of the basic law has set down a very stringent amendment mechanism. It stipulates that the power to amend this law is on the NPC and not on Hong Kong SAR alone. If we are to resolve urgent issues, amendments to the basic law is is akin to growing grass to a starving steed.
Mr. Kwok-him, President. In the 15 years after the handover, the basic law has been successfully implemented in Hong Kong. We owe it not just to the SAR government's hard work, but also that of all people in Hong Kong. In the beginning of the handover, there wasn't sufficient understanding of the basic law, and there were doubts as to whether basic law could protect our rights and freedoms as enjoyed previously. And there were doubts as to whether we could safeguard the rule of law, the legal system, and judicial independence in Hong Kong. However, after proper understanding of the one country, two system idea, and also with the hard work of all sectors of the community, we are able to continue to enjoy the freedoms and rights enshrined in the basic law. According to a survey by the Hong Kong U, that is people's confidence in one country, two systems, we can see that since the handover, the people of Hong Kong has a rather steady confidence in ensuring one country, two systems, and the public are quite satisfied that the administration has helped to maintain all sorts of freedoms in Hong Kong. However, society is changing all the time. To ensure that we have Hong Kong people in Hong Kong, and also to uphold the basic law, the government cannot afford to be complacent. It must continue to hold on to its position and continue to be subject to the monitoring of the community. And that's the reason why I have proposed these amendments to ensure that we have proper implementation of one country, two system. We should safeguard the rule of law, the legal system, and judicial independence. It's not just the duty of the government, it's also the obligation of everyone in Hong Kong. By the rule of law, we do not just mean acting in accordance with the law. Rather, everyone is equal in front of the law. Even the tycoons or the privileged, the accountable officers and civil servants, and even the CE should be subject to enforcement if they have breached the legislation. They should be arrested, subject to investigation, and prosecuted according to the law. In terms of maintaining the rule of law, I believe the government has done a very good job. To ensure that we have the rule of law, we must have a sound legal system. Both the government and the community must insist on acting in accordance with the law. The basic law ensures that we have the right for rallies and also gatherings in Hong Kong, and the people's freedoms should not be interfered with, and therefore the police have the letter of no objection to balance the two rights, and the cases or the principles have been recognized by the court and the CFA many times. I'd like to quote what was said by Mr. Ho Shing, Justice of the Eastern Magistracy. He said that the freedom to take part in rallies and protests is one of the freedoms in Hong Kong. However, the rule of law is also important, and no one can be above the law. And therefore, in ensuring law and order, the police have to issue letter of no objection, and if they are subject to challenges when maintaining order in rallies and gatherings, they are also acting in accordance with the law and upholding the rule of law. In Hong Kong, we have a highly professional police force that adheres to the rig of law. We also have impartial judges to be the gatekeeper. This is because of the hard work of the government and also the community. We hope that we can continue to have the rule of law in Hong Kong. Judicial independence is one of the pillars to safeguard the rule of law. Everyone in Hong Kong, including academics and grassroots, cherish this. In the past, people did not have a comprehensive understanding of the basic law, and they thought that interpretation by NPCSC was interfering with the judication power of the judiciary. However, as the new chairman of the Law Society said, well, each interpretation might give rise to controversies. But then, according to Article 158, the power of interpretation of the basic law shall be vested in the SCMPC. So what the NPCSC is doing is just to discharge its duty under the basic law. In two recent very important court cases, there's been application to the NPCSC for interpretation of the basic law. Such a move shows that the SL government has struck a balance under the one country, two systems policy. It has acted in accordance with the basic law and also tried to avoid speculations that the government is interfering with judicial independence. Yes, the administration has tried very hard to create this impression of interference with the judiciary. The government has a duty, and we need the government and legal professionals to do their part. Here, I feel rather regrettable that some political parties on the one hand talk about the rule of law and the importance of judicial independence. On the other hand, they are targeting a recent court case involving right of abode of foreign domestic helpers. At recent panel discussions and the community, they have openly expressed their views against the application for interpretation of the basic law. This is exerting pressure on the CFA, interfering with judicial independence. It will have an impact on whether the court is going to apply to the NPCSC for interpretation of the law. DAB is very disappointed with this. We hope that legislators can practice what they preach in safeguarding the rule of law and judicial independence. They should not do anything that interfere or say anything that interferes with judicial independence in Hong Kong. Since the handover, the SLG has acted in strict accordance with the basic law in exercising its powers enshrined in the basic law and granted by the central authorities, and has done its utmost to protect the freedoms and rights of residents in Hong Kong. And the work has been well recognized by the central authorities and the local community to ensure that we can more accurately reflect Hong Kong's efforts in safeguarding the rule of law and judicial independence. I have made a simple amendment to the original motion, hoping that I can more accurately reflect the status quo. I appeal to members for your support. Thank you.
Mr. Gary Fan, thank you, President. First of all, I would like to thank Mr. Dennis KWOK for moving this motion to safeguard the rule of law and judicial independence so that we can have a discussion in relation to public policy formulation and how this principle can be applied. My amendment is about this point. The government should not seek an interpretation of basic law, but we should tackle the root of the problem, and that is we should amend the basic law to resolve the problems of baby born in Hong Kong to men and women who have no ties in Hong Kong. The New Democratic Alliance have been following this issue for a long time. These mainland women are competing with locals in terms of maternity beds and formula food for babies. And there are also school places taken up by the babies born to these mainland women in the North District, and local children may have to go to another district for school for education, such as Tai Po. Mr. C.Y. Leung has said that we can tackle this problem with babies born to mainland women by administrative means. According to government information, in the past 7 months, from April to November last year, after the announcement of Mr. C.Y. Leung that administrative means will be resorted to, 15,600 such babies were born in Hong Kong. And that is 3 out of 10 babies born in Hong Kong belong to this category of babies born to mainland pregnant women with no ties in Hong Kong. So this shows that the administrative means will not be effective. When we want to solve this problem, it doesn't mean that we would resort to interpretation of basic law, which, in my view, will affect our rule of law. And the Deputy Secretary General of the Standing Committee of MPC said last year that there will be no need to amend the basic law to tackle these cases, and the Court of Final Appeal should rectify itself. So towards the end of the last year, Mr. Ramsky Yuen, Secretary for Justice, make use of the case involving foreign domestic helpers to ask the Court of Final Appeal to reconsider whether the 1999 Preparatory Committee's views will represent the views adopted by the Standing Committee of MPC. So the administration would like to make use of this case involving FDH to solve the case involving pregnant babies born to mainland women. But this case is about the right of abode of foreign domestic helpers. It's not related to affairs which are the responsibility of CPG or the relationship between the central authorities and the region. Actually, the Preparatory Committee documents appeared only after 6 years of the promulgation, 6 years after the promulgation of the Basic Law. So this is putting the cart before the horse. This is really not following the rule. All governments in the world have enjoyed the right to vet immigrants, but the Hong Kong SAR government has no power to impose any control over immigration. We cannot vet any immigrants from coming into Hong Kong. So if we want to resolve this problem, we should resolve the problem by amending the Basic Law instead of making use of an irrelevant court case to try to seek an interpretation from the MPC. So the government is passing the political buck to the Court of Final Appeal, thus compromising the spirit of common law and the legal system. If the Court of Final Appeal agrees to do this, it will be reversing its previous decision. If the Court of Final Appeal doesn't see to the request, Mr. C.Y. Leung can then blame the court and shirk the responsibility. We are concerned that the government may become reliant on interpretation after this has been done for a number of times. If the judiciary delivers judgments not to the liking of the government, then the government can directly or indirectly ask the Standing Committee of NPC to interpret the Basic Law so that the end result will be acceptable to the government. Dr. Lo Wai-kwok may think that I'm worrying too much, but the fact remains that we have had 4 occasions of interpretations just 15 years after the reunification, and we are going to see the 5th very soon. Every time this is done, the judicial independence we enjoy will be compromised, and gradually will become a place where we have the rule of person, not rule of law. It has been argued that the interpretation of the basic law will have no effect on our judicial independence, such as someone like Professor Chen Wang-ai said that there has been no negative impact because of interpretation of basic law. If this time the Standing Committee of the MPC interprets the basic law in relation to Article 158, then the Standing Committee will be able to interpret any article in law in the future. Well, this is a sugar-coated poison. This is not a solution without undesirable consequences. It's just like a quack claiming to have a successful operation, but the patient died from the operation. The pro-establishment camp is of the view that we should not trigger the amendment mechanism lightly, because this would affect the authority of the basic law. As Dr. Lo Wai-kwok said, if we do this for babies born to mainland women, there will be other requests for amending the basic laws. The authority of the basic law will be compromised. But such concerns are unfounded. Why? If we do not look at what happened in the past, or if we do not do any comparison between constitutions. In our history, we have seen more than 600 written constitutions in various countries. The various the average lifespan is 17 years. The basic law was promulgated in 1991, and it has been implemented. It has been around for 22 years, and since its implementation, it's been 16 years. So it's a middle-age constitution. If we carry out a review of the mini constitution for the SAR and carry out amendments to move ahead with the times, that would be the practicable way forward. After the PRC was founded, the constitution was amended at least 5 times in the 60 years. And the U.S. Constitution has been amended more by 27 times in 250 years, on average once every 29 years. So a constitution is just like an organic matter. It must move ahead in accordance with the needs of the time. So although the process may be a long one, amending the basic law will be the correct and accurate solution. I don't know why the Chinese Communist Party is unwilling to do this. Why don't we amend Article 24 and take away the right of abode enjoyed by babies born to the pregnant mainland women with no ties in Hong Kong? The New Democratic Alliance regards this as our main issue, our main platform pledge for this term of LegCo. We have to safeguard our judicial independence and rule of law. We have to safeguard local interests. So this is a matter of urgency that we should resolve the problem. To solve this problem and remove the conflict between Hong Kong people and mainlanders, we will not accept interpretation. I stress again that the right way and the only way to tackle this problem is to amend the basic law. So I submit.
Mr. Tam Yiu-chung, Mr. President, the rule of law, legal system, and the judicial independence are important assets to Hong Kong, and they will have to be on the system of the rule of law and legal system, and the one country in 2 systems. So we have to give due regard to one country, 2 system and basic law. When it comes to upholding the rule of law, legal system, and judicial independence, if we neglect the basic law and one country, two systems, it will be detrimental. The basic law is something new. There is no precedent. And at the beginning of, soon after the reunification, when the court had to interpret the basic law provisions, they could only do so on the words of the basic law because they do not fully understand the spirit of the legislative intent. And and in the end, the NPCSC will have to invoke Article 158 to correct the situation. It is the 1999 judgment. And under Article 158, when the NPCSC exercises power to interpret the basic law, some people in Hong Kong interpret the power in a narrow sense, and they scaremonger and attack the NPC for interpreting the basic law, saying that it will undermine Hong Kong. And so far, they still claim that courts of Hong Kong have the power to decide on the decision made by the NPCSC. They have neglected the provisions of the basic law and the rights of the central people's government. This will be detrimental to Hong Kong. This does not help with Hong Kong's rule of law and legal system and judicial independence. It also undermines the foundation of our constitution. So all sectors should respect the power to interpret the basic law by the NPCSC. Before the CFA makes a decision about where to refer the article of the basic law to the NPCSC, they should not exert pressure so as to influence the CFA's decision. Just now, Mr. Dennis KWOK, in his speech, described the CFA's decision as the right way or the highway. And Mr. Dennis KWOK is from the legal sector of the functional constituency. I was appalled by what he said. You will have to understand judicial independence with an understanding of the basic law. And I would also like to say something about international definition. According to Chapter 10 of the Human Rights Declaration and also the ICCPR, and also there is the Asia Pacific Legal Association, and also Beijing Declaration. When they assess judicial independence, there are four main principles. First, appointment of judges, that there will not be any interference, and it should be done fairly and just and in a just manner to appoint independent and people with integrity to be judges. Potential prospective judges will not be turned down because of the color of their skin or their nationality, etc. And also there is a guarantee of their term. During the term of the judicial officers, they will not be taken away. And also there is also the extraterritoriality. And number 4, the management of the judiciary, the operation of the judiciary will be done by the court. Executive and legislature will not interfere, and they will have not the right to manage the judiciary. And if we assess our situation with these 4 principles, I think the operation of our judiciary is very independent. So different political groups and members of the public have been striving to maintain our judicial independence. We can see the result. So I propose a minor amendment to the amendment by Mr. Lo Wai-kwok. I want it to be more complete and more precise to correctly reflect the situation of Hong Kong. Hong Kong people should not be affected by words like clouds, a storm approaching Hong Kong, and we should all work together to uphold the rule of law, the legal system, and the judicial independence.
Secretary for Justice. President, whether we look at the system or the implementation of the system, Hong Kong SAR government has always been upholding the one country, two system, and in accordance with the basic law, upholding our rule of law and judicial independence. In the coming years and days and years, we'll continue to uphold the same position. The one country, two system principle is the basic foundation for setting up the SAR. When sovereignty is resumed by the CPG, we set up the SAR, and the basic law states clearly that we have a high degree of autonomy, and we enjoy independent powers in relation to the judiciary and other powers, executive powers, including final adjudication powers. We do not have to pay tax to the CPG. We can have our currency. Our people do not have to serve in the PLA. We can issue passports to qualified citizens in Hong Kong. All these have shown that we are successfully implemented the principle of one country, two system. There are clear provisions in the basic law to preserve our previous laws in force. So unless those are in conflict with the basic law. Also, our basic rights and freedoms are protected by the basic law, our BORO, and relevant laws. Article 19 also protects the Hong Kong SAR by offering our judiciary independent judicial power, including that of final adjudication. The basic law provides the safeguard for SAR and implements the CPG's policies on Hong Kong. In the 15 years after the reunification, the SAR government has been working hard to implement the safeguards and uphold one country, two system. The rule of law and judicial independence form the cornerstone of our SAR and is our core value. Article 85 of the Basic Law states clearly that the courts of the Hong Kong SAR shall exercise judicial power independently, free from any interference. There are major articles in the Basic Law providing for the appointment of judges and protections for them. Also, in relation to appointment of judges, we have to follow an established procedure. Their salary and benefits are also protected under law. Their judgments may not be in line with the government or the general public's preferences. Their appointment will not be affected. A judge can only be removed under very serious cases of misbehavior. This ensures that our judiciary remains independent. The Basic Law also stipulates that the SAR courts can make reference to the judicial judgments in other common law jurisdictions. The Hong Kong CFA can also invite other judges from other jurisdictions to take part in the work of the CFA. After the establishment of SAR, we have been implementing and developing our legal system under the Basic Law. Under the new constitutional structure, our judicial independence and rule of law have been protected and safeguarded. No one, including the government, is above the law. The judiciary would only look at the relevant laws and the relevant legislative intent to make judgments. They are not subject to any interference from the executive or from any other outside parties. and our judiciary that is widely recognized and supported internationally. In last month, a local office was set up by the Hague Judicial Organization, and they have cast a vote of confidence in one country, two systems, and in the SAR. According to the basic law, our courts enjoy the right to interpret the basic law and exercise their powers independently. Under Article 158, there is a restriction, and that is the power of interpretation shall be vested in the Standing Committee of the MPC. And Hong Kong courts can may interpret the provisions in the law in adjudicating cases. However, in certain cases, the CFA will have a duty to refer the case to the Standing Committee of the MPC for an interpretation. Under the third paragraph of Article 158, there is such a mechanism. This is part of our constitutional setup, and it's also part of our judicial system. Whether to seek an interpretation from the Standing Committee of the MPC is something for the Hong Kong CFA to decide under the common law system and under the relevant provisions in the basic law. The SAR government and the Standing Committee of the MPC cannot affect the decision of the CFA in this regard, as the appeal case is still pending adjudication. I or any representative of the SL government should not or is not in a position to say anything of the argument that we are going to advance in the court. But simply put, in the case involving the right of abode of foreign domestic helpers, the SAR government has asked the Court of Final Appeal to consider seeking an interpretation in relation to Article 158. This is just a proper legal procedure. There's nothing that would affect the independence of the judiciary or the rule of law or the separation of powers as alleged by Mr. Dennis KWOK. And we are not asking for an interpretation in relation to Article 24. We believe that the Court of Final Appeal would come to a just decision as they have always been doing in the past. One country, two systems, and the basic law are the foundation of the SAR, and the rule of law and judicial independence are also instrumental for Hong Kong's status as an international financial center. The SAR government and the Department of Justice have been working hard to uphold the spirit of the rule of law and judicial independence, and we can promise that we would continue to uphold this position. I'll listen to members' speeches before I respond further. Thank you, Mr. President.
Ms. Claudia Mo. Thank you, President. The original motion says right in the beginning to uphold one country, two systems. This is something that no one can dispute or object to, and also agree to the amendment by Mr. Gray Fan. And this kind of interpretation is like the martial tricks of Jie Shen, a famous master in Jin Rong's Kung Fu fiction. I think it is even a more harmful move, which will harm both himself and his enemies. Well, I think one country, two system, and high degree of autonomy is very sensitive. How do you define a high degree? Maybe your standard of high level of autonomy is different from mine, so it's open to interpretation by different people. Since the handover, we've seen numerous interpretation of the basic law initiated by the SAR government. And you can see that the rule of law on the mainland, to use more modern terms, has a lot to be desired. There is a lot of room for improvement. Well, Mr. Liu Xiaobo won the Nobel Prize of Peace. How come he's still in jail? And why is it that somebody is said to have committed suicide while he's just been while he is under custody? So I've just quoted a few examples, and people will stand up to support these people on the mainland. People will say that, well, the well water should not interfere with the river. Why should we point fingers at what's happening on the mainland? Because what I said was about human rights, freedom of the press, human rights, and freedom of expression. These are universal values, not just Hong Kong's values. At the end of the day, what is the greatest fear of Hong Kong people? We are worried that what has happened on the mainland, what is happening on the mainland would happen in Hong Kong. That is, today's mainland may be tomorrow's Hong Kong. Well, I would also like to echo what Mr. Gary Fan said. We must uphold our local culture, our own core values. We must defend Cantonese as a dialect, and we must defend the traditional Chinese characters, script we have been using in Hong Kong. Well, there is these two different concepts, the rule of law and the rule by law. On the mainland, they do not just have the law. They do not just have the rule of law. They will pick a particular legal provision to charge you. People have the impression that there is no judicial independence, and there is a lot of cases where we see the rule of men. Otherwise, we won't be able to explain what has happened to the Nobel Prize laureate Liu Xiaobo while he is still in jail. And under the Constitution, there is protection for freedom of publication and freedom of expression. And how do you explain what happened to Nanfang Zhou Mo periodical on the mainland, and also another journal on the mainland? They're using various means to suppress dissenting voices. I dare not say that in Hong Kong this has happened unreservedly. Well, it's not still very blatant, but the fact is, well, a photographer of media was carrying out his usual duty of covering current events, and then he's been charged of common assault. Luckily, he is acquitted. Well, you may say that since he is acquitted, then we are happy, we have no cause to worry. But you cannot imagine how somebody can be arrested, and that after a long legal proceedings, he is acquitted unconditionally. So what's happening in Hong Kong has set chills down our spine. So the freedom of the press is the last protection we have. Without freedom of the press, without the media as your gatekeeper and to monitor, you don't know what's happening in society. You want to safeguard the rule of the law. You want to safeguard judicial independence, but you don't know what is happening. You want to protest on the streets, but you don't know what to protest about. According to the press, under the company's ordinance, people are not allowed to search the company registry anymore. This is really very shocking. In a civilized society, I'm of the view that public interest should always prevail over privacy. Well, for celebrities and stars, movie stars and senior officials, your privacy cannot be put on the same footing as the privacy of your neighbor, Tom, Dick, or Harry. Well, the freedom of the press has exposed many great and important news for us. Without freedom of the press, I don't know whom should I speak to. Well, even if you have the rule of law, you don't know who to penalize. Yes, we should safeguard the rule of law, the legal system, judicial independence, and also the freedom of the press. Let's not let Hong Kong's future be like mainland today. Mr. Lee Chek-yan, thank you. On behalf of the Labour Party, I must express my strong objection to Mr. Tam Yiu-chung and Mr. IP Kwok-him's amendments because, well, they have the concept that we should continue as if things were perfectly in order so that we can just continue to uphold what we have now. But in fact, our rule of law is very fragile and vulnerable and under threat. According to Justice Bakri, judges must stand up in the storm. He has this strong sense of crisis and impending danger. So you can consider judges are in the storm and they can feel that it is coming. So the two words continue to is a departure from the reality. There has been challenges to the rule of law. This is not the first occasion of interpretation by the NPCSC. And even on the last occasion, there was something wrong with the procedure. The SLG made a direct application to the NPC. Now, if you look at Article 158, the first paragraph, the power of interpretation of this law shall be vested in the SCNPC. And second paragraph, Mr. Martini, an ex-member of the drafting committee of the Basic Law, says that the Standing Committee of NPC shall authorize the courts of the Hong Kong RO to interpret on their own in adjudicating cases the provisions of this law which are within the limits of the autonomy of this region. There are only in two areas where interpretation by the NPCSC should be sought, and that is affairs which are the responsibility of the CPG or concerning the relationship between the central authorities and region. There is nothing here to say that the SAR government can make a direct application to the NPCSC, but of course you can have all the say, and you can say that the first paragraph is the authority you rely on. Can one legislature here ask another legislature, that is the NPCSC, to interpret the law for our own judiciary? So we are not happy with the two words continue to. And we're also not happy with the provisions in the Basic Law because the articles in the Basic Law is a threat to our rule of law. They can stealthily, or rather not stealthily, you're doing it in the openly. Everyone in Hong Kong knows what you're doing it. Now, if you have done it stealthily, at least you have a sense of conscience. I think you are blatantly, you have made an open application to the NPCSC for an interpretation. You have done this in the past. You have threatened our judiciary. You may recall that all barristers, perhaps the SWJ should tell us whether he was present. There was a protest by the legal sector in black. They wore black to protest this move. Perhaps the SWJ can tell us what his feelings were back then, because we're worried that our rule of law was being threatened. And what about this time? The court has been asked to make an application to the NPCSC. Now, this is not directly done by the SAR government. Rather, the court has been asked to do that. And the case itself is strange. A right of abode for foreign domestic helpers. What does it have to do with the relationship between the central authorities in the region, and also concerning affairs which are the responsibility of the CPG? And then you want to lump in the question of mainland mothers giving birth in Hong Kong into that issue. How are the two related? Mr. Tam Yiu-chung criticized Mr. Dennis KWOK for not accepting something when put to him in courtesy, and that he is allowing, or rather Mr. KWOK was exerting pressure on the CFA. Who is the party? Which is the party that has exerted pressure on the CFA is the SAR government. Mr. Dennis KWOK said that a sword is hanged above the court. I think what the administration has done is to ask the court to castrate itself or for the government to castrate it. Mr. Chairman, a professor of law, has put it very clear. The administration has never answered this question from the legal sector, all right? You ask the court to apply to the MPCSC for interpretation of the basic law. If the court refuses to do so, will the SL government undertake to respect the ruling of the CFA and will not directly ask MPCSC to interpret the law? Can there be an answer to this question? Now, if the administration refuses to answer, then I think you, to borrow Mr. Chairman's words, you want to have the best of everything. Can you explain today, make yourself clear? If the CFA refuses to apply for an interpretation to the MPSC, will the government do it itself? If you're not willing to answer, then if you're not exerting pressure on the court, what are you doing? That seminar has made it very clear. Even many lawyers in Hong Kong are questioning whether the MPCSC should have the power to interpret the basic law. Now, if we are doing this, then we are inferior to the mainland. We are even more backward than the mainland. We call ourselves a civilized society where we have the rule of law. We're even more backward than the mainland. And regarding Mr. Gary Fann's amendment, we'll abstain from voting because I think that whether we should seek an amendment to the basic law to resolve the mainland mothers giving birth in Hong Kong issue, we should wait for the outcome of the population policy review. Ms. Albert Ho. Well, I think the one country, two system is a contradiction.
Well, the one country, two system, for one country, it is under the rule of central authorities. It is of the size of 360,000 kilometers, and or 3.6 million kilometers. And whereas Hong Kong is only 1 kilometers. Well, we in truth have no democracy. We have separation of power, and we have the rule of law, and also judicial independency. The two should coexist. Is it difficult? And for the authority who manages at 3.6 million square meters, they still have some degree of control over Hong Kong. Under the one country, two systems, there is an issue of authorization. And the as for Jay said that under Article 31, and we have the high degree of autonomy, and because there is an authorization. But you have to fully understand the meaning of authorization. Otherwise, we will not be able to discuss it, because we're talking about authorization of a single authority that which will oversee everything. The design of the basic law is to give Hong Kong give Hong Kong complete power of executive, judiciary, and legislative, so that we have high degree of autonomy. So it is exclusive. It is complete. If there is any interference, then it's over. Because you can say, well, this is wrong, and the next day something else is wrong. So the concept is not about a delegation. It should be a devolution. Let's look at 158, Article 158. Let me give you an example to illustrate. Clause 1 of Article 158 is about where the power comes from. The second clause is about the delegation. There are different areas. We have areas of high autonomy. And the third part is about the judiciary, where it involves powers of the central authority. There is a procedure for the matter to be referred to the central authority for it to exercise its power. There is a structure, a system. If we do it in accordance with Article 158, there should be no fear. In the past 4 occasions with interpretation, when it comes to the Congo case, well, because it is done in a strict accordance with 158, so there is no controversy. Of course, we are not too happy about the result because it's too wide. It doesn't really matter. Whereas for the other 3, it's ridiculous. The first one, 1999, rise of uphold. The administration lost the case in the CFA. Then they went to the NPCSC asking for an interpretation. There is no such provision in Article 158. Well, the result may be the same, but they have in effect overturned the ruling of the court. Back in 1999, a member of a Human Rights Committee asked me whether Hong Kong still have the right of final adjudication. And on top of that, it is a political body that overrides a judicial body. The second occasion is about a constitutional reform. Hong Kong people were kept in the dark. There was no system. There was no procedural fairness. There was no information about why there should be 3 steps or 5 steps. No one said anything. When it was reviewed, it was forced onto us. The third occasion is about the explanation of the term. What is the term referring to the remaining terms of the CE? Mr. Albert Chan filed a judicial review. When the case was being heard, the administration sought interpretation. So it can be done at any time before the case goes to the court, during a hearing or afterwards. You can go and ask for interpretation. How can we not worry? Let alone that the interpretation can be retrospective. It may not affect a decision made in a certain case, but it has retrospective effect. So people who are not in the case may be affected. So this itself is very important. If on this occasion the S4J asks for reinterpretation in relation to Article 24, well, I'm glad to hear that it's nothing to do with Article 24, but I don't know what it's about, because Article 24 made it very clear that this is Hong Kong's autonomy. We have exclusive jurisdiction. We can make our own decision, which is very important. And the remaining issues. S4J, what interpretation are you seeking? Can you tell us? Because it may affect a lot of people. It has retrospective effect. It affects the whole of Hong Kong. How can we not have some discussion? Don't forget that the whole process is kept from Hong Kong people. It is not a legislative process, nor is it a judicial process. It is only a political process. That's why we're very concerned. If we act in strict accordance with Article 158, I don't think people will be so fearful. Mr. Tam Yiu-chung criticized other members. I think he's just nonsensical. He's just helping the bully. I think he should reflect on this. Mr. Ronnie Tong. Mr. President, well, there were 2 friends, A and B. One day they met again. A said, recently I've been to India. I saw a strange animal called an elephant. It has a long trunk and huge ears. And B said, no, I've been to India and I've seen an elephant. Elephants have 2 huge ears and a long trunk. And they bickered, and they went to India together to find the answer. They went, and they saw an elephant. They said, as I said, it's 2 huge ears and a long trunk, and it's an elephant. And are you saying the right thing? Because I said it was it has 2 huge ears and a long trunk. So the 2 of them fought, and they've separated since then, and we've lost 1 country, 2 system. I am puzzled by the amendment. What do you mean by continue to uphold 1 country, 2 systems and safeguard the rule of law of Hong Kong? What is the difference? I was listening intently at Mr. Lo Wai-kwok. You're both talking about the Pope's Catholic. But one said that the long trunk is more important than the 2 ears, whereas the others said that the 2 huge ears are more important than the long trunk. So this is indeed a very childish bicker. In the end, 1 country needs to respect 2 systems, and 2 systems need to respect 1 country. Whichever one comes first. And if someone say that it means it diminishes the importance of the one that comes after, I think this is meaningless. Do we have to, if we get bogged down by insisting that 1 country should come before 2 systems or the other way around, then we will lose 1 country, 2 systems in the end. The rule of law is the rule of law. Of course, with 1 country, 2 systems, we have rule of law. Even without 1 country, 2 systems, we should still have rule of law. And on the mainland, there should be the rule of law. But whether that is actually practiced is a completely different matter. And this is nothing to do. This doesn't really have anything to do with 1 country, 2 systems. What are we doing here? Mr. Dennis KWOK moved this motion. I think he had a very strong feeling towards this. It's just that he's being subtle. Recently, the S4J, Mr. Rimsky Yun, made a request for the CFA to seek interpretation from the MPCSC. One of the most important area of the rule of law is not that everyone is equal before the law. It's the fact that the administration, the government, is subject to the restrictions of the law. That is the most important area in modern society. And it's also a cornerstone of a free and democratic society. If a government refuses to be subject to the law and use political expediency to circumvent legal requirements or principles, then the government is destroying the rule of law. Interpretation itself will not destroy or damage the rule of law, because interpretation is enshrined in the basic law, and this is the mini constitution of Hong Kong. But if someone uses interpretation to achieve a political goal, then they will damage the rule of law. And I think we have a prime example of a destroyer of the rule of law after reunification. He is Mr. Tung Chee-hwa. In 1999, in the Ng Ka-ling judgment, Geoffrey Ma was asked whether there was any need to interpret the case. The answer was no, and then the government loses the case. Mr. Tung Chee-hwa, when alighting from a flight, said that that is unacceptable because we have 1.6 million people coming from the mainland, and he's been proved wrong by history. And I think the worst thing is that the government wanted best of both worlds. After the ruling, they went to seek interpretation of from the NPC, ignoring Article 158. And now we're talking about hundreds of thousands of babies born to mainland women with no Hong Kong ties fighting for school places or formula milk. I don't know whether this is another political lie. And the situation is worse than the Inca Ling case, because in the Inca Ling case, we're talking about Article 22, which is about the relationship between Hong Kong and the mainland. But now, what is this case about? It's about foreign domestic helpers. What does it have to do with relationship between Hong Kong and the mainland? If it has no relationship, then why? Because of political reasons, seek to overturn the Zhang Fengyun case. Why do you have to seek interpretation? If you are not destroying the rule of law, what are you doing? Not only are you destroying the rule of law, you're destroying the one country, two systems. Because a lot of people are now talking about which comes first, one country or two systems. And they've been divided. Your offense is a serious one. So I ask Rimsky-Yuen to withdraw his application.
Mr. Frankie Yik, President, one country, two systems is the policy of the central government towards Hong Kong SAR, is also the core spirit of the Basic Law. The core values of Hong Kong, including the rule of law, the legal system, and judicial independence mentioned in the original motion, are indispensable elements of one country, two systems. With these core values gone, the stability and prosperity of Hong Kong and also a way of life will lose their basis. Hong Kong is a world financial center and also an important logistics center. However, if we do not have a fair legal system, if our judiciary is no longer independent, and if cases cannot be heard fairly, then investors' confidence will be shattered. And then there will be no more safeguards for the way of life and freedoms of people in Hong Kong. They will then have no confidence in Hong Kong's future, and therefore the impact can be far implications. And therefore the LP attaches a lot of significance to the upholding of one country, two system, and the rule of law, the legal system, and the judicial independence in Hong Kong. Mr. Kwok's original motion, as well as the amendment by Dr. LO Wai-kwok, Kwok-him, and also TAM Yiu-chung, they might differ slightly in content, but the central spirit is to safeguard one country, two system, the rule of law, the legal system, and judicial independence, and therefore we support all of them. As regards Mr. Gary Fan's amendment, he says that the government should not seek an interpretation of the Basic Law, but should an amendment to the Basic Law to address the problems of babies born in Hong Kong to pregnant mainland women. Well, the interpretation or amendment of the Basic Law is a serious issue and should only be taken as the last resort. The Basic Law is our mini constitution, and if we seek interpretation and amendment of the Basic Law too lightly, this will undermine our stability. Well, the root of the problem of mainland women giving birth in Hong Kong stemmed from the Zhang Fengyun case. We believe that cases should be settled within our judiciary. The S4J has recently requested the court to apply for interpretation of the Basic Law on who has the right of abode here. Well, even Mr. Justice Buckley has said that this is an impending storm. However, the S4J has made this application in full accordance with the law, and that he has every confidence in our legal system. The final outcome of the S4J's move awaits to be seen. However, the LP and I are of the view that we should have every respect for our judicial independence. Although the administration has indirectly sought an interpretation by the NPCSC, the final decision rests with the CFA, and therefore we believe that it is not totally unacceptable. Because of this, we oppose Mr. Gary Fan's amendment. Thank you. Mr. Ng Leung Sing. Thank you, President. The basic law was made under the national constitution. In particular, under Article 31, there is the concept of one country, two system. That's under Article 11. And then the joint declaration is also a basis for Article 11 and also Annex 1 to the joint declaration. And Hong Kong SR is vested with the power of adjudication and final adjudication. Our way of life, our laws will remain largely the same. Of course, society would progress. Our legal system must tie in with our economic development and should be modernized from time to time. It's just like our amendments to the Companies Ordinance and the Banking Ordinance. We have made amendments to these ordinances recently on the same basis. The momentum of legal amendments in Hong Kong have come from our economic development, and it is for the SAR government to tackle them on our own and not at the request of the central authorities. Since the handover, our rule of law, our judicial independence, and our legal system have not been changed at all. The amendments have the words "continue to." I think this is a correct description of what's happening. It shows that the status quo has not been changed, and there is no reason to change the status quo so long as move along the existing direction. At the beginning of this month, the S4J was interviewed by the press. He said that frequently there are criticisms that the central authorities have interfered into judicial independence of Hong Kong. However, he is of the view that the mainland has always helped us to promote the rule of law. For instance, in the Hague Convention, well, it's a convention, an intergovernment organization to promote judicial independence or the rule of law. And that the first Asia-Pacific office was set up recently in Hong Kong, all because of the discussion between the host country and the central authorities. The S4J has requested the CFA to seek a clarification from the NPCSC on the right of abode issues involving foreign domestic helpers and babies born of mainland mothers in Hong Kong. I think it is pragmatic for the government to do so. We should try to find a pragmatic solution, a proper solution for these issues. And we should try to avoid differences in ideology. First, these are legal issues and cannot be settled by administrative means. We should seek a fundamental solution through legal means. Secondly, these are caused by rulings of the court, and therefore it is appropriate and reasonable for the court to resolve the matters. And then under Article 158 of the Basic Law, the power of interpretation of the Basic Law shall be vested in the SCNPC, and the CFA may apply to the Standing Committee of the NPC for interpretation of provisions of the law. Well, since the handover, there have been 4 applications from the SLG to seek interpretation of the basic law by the NPCSC. The most recent one was done in June 2012 regarding the Congo case, and then two previous cases were initiated by the SLG. Has these undermined the rule of law in Hong Kong? As the legal expert Mr. Chen Hong Yi said, for the two interpretations, they were focused on individual cases. There was no direct negative impact on the operation of the judiciary. So I'm of the view that the comment that interpretation by NPCSC would undermine our rule of law doesn't hold water. I think it is a proper way to tackle problems we have in hand. Thank you.
Mr. Charles Mok. President, this motion moved by Mr. Dennis KWOK is a very good one. It's very to the point. With just more than 20 words, he has pointed out our situation. Uphold one country, two systems, safeguard the rule of law, the legal system, and judicial independence in Hong Kong. Well, I'm not a lawyer, but I'm a businessman, and I have offered professional services. I understand the importance of the rule of law and judicial independence. Well, I've been involved in some lawsuits, and I have went to different courts. And I have always been confident in the rule of law and our judiciary. But the recent remarks and action by certain parties have dealt an unprecedented blow to the system, thus affecting our confidence. If we are to go to the court again, if we have any doubt concerning the impartiality and justness of the court, the consequences can be very grave. Well, what is rule of law? In Chinese, we talk about the spirit of the rule of law. Well, the rule of law is about about the spirit. And it has always been confused with rule by law. Thank you. It's a common confusion that it's just rule by law. Some people think that rule by law is just rule of law. Well, whether it's a law by the edict or laws in a democratic country such as China's laws or in a totalitarian state, they all have rule by law in the strictest sense of the word, or they may not comply with the legal requirements or the laws themselves. Rule by law is about what the government would do, but rule of law is just a spirit. It's not just about following the law, but it's a system whereby you have some checks of balance against rule by law, and to impose some restriction on government's powers. In other words, I think rule of law overrides rule by law. It prevents abuse of power. If we violate the law, it doesn't mean that we are violating the rule of law, because even with rule of law, there's still scope for civil disobedience. Otherwise, the founders of the PRC would all be the offenders. But they were against the unjust laws. The rule of law is important in upholding the spirit of the legal system. Otherwise, the laws would just be something that has a substance but no spirit, and that will be ignoring the rule of law. We cannot say that we are physically strong, even with an impact dealt to the rule of law. I'm just concerned that our independence and judicial independence and rule of law may not withstand such impacts. Well, it's important to us, not least in the economic sense. Every time I talk to overseas businessmen or people from the mainland, and when we talk about our advantages, and even Invest Hong Kong in trying to promote Hong Kong, will refer to our environment with rule of law. There are many companies which have come to Hong Kong to set up data centers precisely because our legal system offers protection to intellectual property rights, and we have freedom of flow of information and highly efficient matching of facilities and demand. We are very efficient because of the system. For example, Hayek highly respected our economic system. This is how he looked at the relationship between the rule of law and economics. When he refers to rule of law, everyone can make an informed decision on investments and plan their future with rule of law. You can do that, and you are confident that you can get a return. In a recognized system, in a publicly recognized system, everyone is free to pursue his personal ends and desires, and the powers of government will not be used to frustrate his efforts. But this is a very clear delineation of the relationship between the government and individuals under this system. I would like to say this to members from functional constituencies. Well, if we undermine the rule of law, we are undermining our economy. Well, rule of law is defined by Hayek as contrary to the arbitrary government. So what is arbitrary government? And that is the Executive Council's example in dragging its feet in granting licenses for free-to-air TV. There are so many examples. We know that gradually we are seeing the emergence of undesirable consequences, and we are seeing that our image sinking to a new lows. I think we should all recite this motion moved by Mr. Dennis KWOK. So in our liberal studies lessons, we should all recite the same lines. We should uphold one country, two systems, safeguard the rule of law, the legal system, and judicial independence in Hong Kong. So I submit. I support Mr. Dennis KWOK's motion. Dr. Kenneth Chan. Thank you, President. Everyone talks about the rule of law. Everyone can talk about this. Everyone says he's supportive or uphold the rule of law. From the previous debates, well, if we didn't listen very carefully, we would have thought that it's very good. In this council in Hong Kong, it seems there's a bipartisan consensus that the rule of law and judicial independence is our core value, the cornerstone of our success, and we must safeguard this and we must develop it further. But if you look deeper into that, some would say that so long as we have laws, so long as we trust the power that be, and we must trust that those who are in the Executive Council know best how to safeguard our welfare. Under the one country, two systems, we have above us the Standing Committee of MPC, but very little analysis is offered about what this highest power of the nation, i.e. the MPC, is like, whether it's representative, and ultimately what kind of power, organization, or authority the MPC is. We have witnessed the lawless days. Many of our citizens came to Hong Kong as refugees fleeing the mainland from political persecution. Every people knows about what's meant by persecution, by one-party rule, and the sacrifices and the prices to pay for such a system. under the one country, two system, we are protected. We have Hong Kong people ruling Hong Kong, and we hope that in the future we are going to see real democracy implemented here. So the upholding the rule of law and judicial independence has constitutional significance. It's not just for Hong Kong. We would like to see that the rule of law and judicial independence, not just for Hong Kong, not just to continue to develop in Hong Kong, but we also hope that it's also as enjoyed by the people in China. Without the rule of law, powerful people or powerful mainland authorities can interfere with our affairs, although they won't say this as such. As just like Mr. Zhang Xiaoming said, they are not ruling Hong Kong. Well, they can say what they like. If there is no rule of law, the executive will not be subject to any checks or balances, and they will have introduced a totalitarian regime in Hong Kong. They can interfere. The CPG can interfere with Hong Kong's policies and the laws. Without the rule of law, many business activities, economic activities would be rather in the abstract. We must, in that case, it's better to know the important people rather than know the law. Investors will have no incentive to invest here. And it's said that without the rule of law, Hong Kong is just another Chinese city. Such remarks and such sentiment reminds us that if we don't have a rule of law, we are not an open and transparent and just society. And then we would find people guilty of speech. We are going to have a Mr. Liu Xiaobo, Mr. Liu Xia Hong Kong versions. Hong Kong will become more and more corrupt. How would the rule of law be impacted upon? In the last few months or since the reunification, we have deep feelings about this. L.C. Leung said something recently. The government was very slow in reacting to his or to her speech. It's disappointing to many people who are very concerned about the rule of law. It's not just about freedom of speech enjoyed by Ms. Leung. We have to remember that he's an important member of the Basic Law Consultative Committee, and he or she did not conceal her or did not mince his words in criticizing our courts and our judges and our officials who are responsible for safeguarding the judicial independence of the rule of law seem to be very evasive and slow in reacting to her remarks. When Expert J was asked to seek a solution for addressing the right of birth of babies born to mainland women, he ultimately tried to seek an interpretation, an absurd proposal in my view. Mr. IP Kwok-him's proposed amendment is to add the word continue to. On what basis? Does he think that this government returned by a small circle of voters have been upholding one country, two systems, or the rule of law and judicial independence? Or is it that Mr. Yip and DAB don't think that this is important? Dr. Lo Wai-kwok is also, Dr. Lo Wai-kwok's amendment is also puzzling. He wants to add the words in accordance with the principle of one country system and the provision of the basic law. And he's trying to give us a lecture on how to understand the importance of MPC, how can we better understand the political system of the mainland. Well, I'm a professor of international politics. Of course, I understand what's really the real politics. They don't comply with the laws, although the laws are there. The laws are the tool to clamp down on your enemies, and the laws can change over time depending on needs. our rule of law and judicial independence so that we can uphold one country, two systems, and we can continue to make a contribution.
Mr. Jeffrey Lam, it's been 15 years since reunification. We have seen storms. Society is still stable, and our economy continues to develop. This is thanks to one country, two systems, Hong Kong people ruling Hong Kong, and high degree of autonomy, and of course the hard work of Hong Kong people working together. What is more important is that we have a stable system. Hong Kong is like a ship or a boat sailing in a stormy sea. Apart from a sturdy helm and a sturdy hull, we need people to work together, and also a good guidance and a good navigation manual, and that is the basic law of Hong Kong. The basic policy, according to the basic law, is that there are two systems under one country, and the basic law will be the Constitution of Hong Kong, and this will be the basic system of Hong Kong. So we see that the one country, two system principle has to be protected by the basic law. The judiciary, executive and legislative are protected by the basic law and have to act in accordance with the basic law. And it says under Article 11 of the basic law, it says that when it comes to the social economic systems and also the relevant policies and administrative policies, and this will be done in accordance with the basic law. So the original motion says to uphold one country, two systems, and safeguard the rule of law, the legal system, and judicial independence in Hong Kong. We agree with that. But the status and the role of the basic law is equally important. Basic law is the cornerstone of our success. Our spirit of a rule of law and legal system and judicial independence cannot be separated from the basic law. And this also relates to the high respect of the basic law, and the implementation of the basic law is under the understanding of the NPC. And we get a high degree of autonomy from the basic law. We enjoy high degree of autonomy. We have judicial independence. That is stated in the basic law. But I see at the same time that some people override the basic law with its own interpretation of the rule of law and judicial independence, and interpret that the central authority cannot interfere with any affairs of Hong Kong apart from foreign affairs and other affairs. I'm not going to speculate what their motive is, but this is not in line with the basic law and one country, two systems. There is a change in the atmosphere in society. Simple matters are politicized. When it comes to Hong Kong's development and the governance of the administration have different expectations, it can be expressed by different ways. Recently, some people abused the judicial process to hinder policy implementation. Recently, there has been a press report that the S4J asked the CFA to seek interpretation of the basic law. Well, the case is sub judice. Some people released information to the press, and this is not appropriate. The S4J is a party to the case, and it's always the practice that different sides will have their own argument. Is it the case that stating your own argument amounts to exerting pressure? Some people say that judicial independence should be upheld. And at the same time, they say that you cannot comment on cases sub judice. However, in this case, they comment that the S4J is exerting pressure on the judiciary, and they are afraid that the CJ, Jeffrey Ma, will succumb to pressure. I want to ask, who is actually exerting pressure? We've always respected judicial independence. We thank the system for giving us very fair society. We urge the administration to continue to safeguard Hong Kong's rule of law. And I ask some people in society not to adopt a double standard and want the best of both worlds. I so submit. Mr. Raymond Wong. Mr. President, Mr. Dennis KWOK represents the legal sector of the functional constituency. Today, he moved a motion on safeguarding the rule of law and judicial independence. That is what he's supposed to do. We are the opposition. Of course, we will support this motion of safeguarding the rule of law and judicial independence. However, it's just words. We are indirectly ruled by an authoritarian state, that is the central authority. When it comes to protecting our human rights and rule of law and legal system, it will diminish. As long as there is a Communist Party, there will not be the rule of law. That is common knowledge. Back in 1980s, Peng Zhen, a powerful figure in the Communist Party, was asked whether the party is more powerful than the law. He said he did not know. And Wu Bangguo, he's the head of the NPC, said that our rule and regulations and our laws are under the leadership of the party. All our rules and laws is to improve the rule of the party. And they are there to consolidate and reinforce the leadership of the power. Also, there was another figure, Mr. Rimsky-Yuen. He was once a delegate of the CPPCC. He asked of Guangdong, and he asked the CFA to seek an interpretation in relation to the Ng Ka-ling case in 1999, and he said that this will be used to resolve this can facilitate a proper interpretation of the rights of both for all categories of persons and also the babies born to women with no mainland ties. I think he just arrived roughshod. In 1999, the chief executive and the executive circumvented the CFA, submitted the case for interpretation in 1999 and 2004. That was interpretation of Annex 1, and in 2005, the CE Donald Zhang, the acting CE Donald Zhang also sought an interpretation. In 2011, that was the fourth occasion when the CFA sought interpretation in relation to the Congo case, which was also controversial. I would like to quote some words to you, Mr. President, and the S4J, and the few number of legislators who are sitting here, although we don't have a quorum. Yesterday, the CFA finished hearing with a case of babies born to Hong Kong residents. They have made a ruling. At the same time, the CJ, the Chief Justice, Mr. Andrew Lee, said in the judgment that the Hong Kong SARG does not need to seek interpretation from the from the NPC. We have the right to interpret the provisions of the basic law. This is in line with the one country, two system. As long as if it is something to affect the central authorities of foreign affairs or the relationship, then we don't have the right. And our interpretation is done in accordance with the relevant provisions under the Basic Law. And this is the time when we exercise the power of the CFA. Now, this has shown a high degree of autonomy. The result of the ruling is in line with Basic Law. And Article 3 of the Basic Law is about Hong Kong's people's right and obligation. And Article 24 is in relation to babies born to mainland babies born to Hong Kong parents. And when eligible persons who can the non-permanent residents of Hong Kong SARG shall be persons who are qualified to obtain Hong Kong identity cards in accordance with the laws of the region but have no right of abode. And we welcome the CFA's ruling in relation to the rights of abode case. The ruling of the CFA has reinforced the high degree of autonomy and our understanding of the Basic Law. The ruling of the SFA is a test and a breakthrough since the establishment of the of the Hong Kong SARG, and the effect is positive. I've quoted this lengthy article because this is the editorial of Da Gong Bao dated the 30th of January 1909. The paper is a mouthpiece of the Communist China. Have you read this, Mr. Yun? On the 29th of January 1909, the CFA made a ruling. However, the Hong Kong SARG ignored the ruling and asked for the help of the CPG for an interpretation. And on the next day after the ruling, this is the editorial of the Da Gong Bao, and it has highly valued the ruling of the CFA. Mr. Jeffrey Lam and a lot of pro establishments are talking nonsense here. Please listen to me. I've quoted the editorial. Did you listen to me clearly? It's on the record of the LegCo. And I think the barristers did not say it as well as this editorial. What does this show? This shows that our understanding of the CFA ruling is perfectly in line with the Basic Law, and the interpretation is not. And you so shamelessly say these words. You have no right to do so. Rinsky Yun, you have no right to be saying what you said. The CFA has its own independent mind to decide when to seek interpretation. You have no position to ask them to do so.
Ms. Emily Lau, I speak to support Mr. Dennis KWOK's original motion, and that is that this Council urges the government to uphold one country, two systems and safeguard the rule of law, the legal system and judicial independence in Hong Kong. Chairman, many members, including those from the business sector, have spoken on this motion. I think we should all know how important it is, the rule of law to a prosperous society, because many local and overseas investors have chosen to invest in here because we have an independent judiciary, and when there are any disputes, they can seek an arbitration by the court. And the people in Hong Kong are very concerned that we have an independent judiciary to safeguard their human rights. Come this March, the UN Convention on Human Rights will convene a hearing on how the SLG has complied with the relevant conventions to safeguard social and political rights and civil rights of people. All right, this is a consensus. I hope that this motion or this debate will not come to nothing. Otherwise, it will send a very negative message to the community. And I have heard support for Mr. KWOK's motion, and let's wait to see the voting results. A number of members have mentioned Ms. Elsie Leung, the former S4J. he criticized the judges for not understanding China SAR relationship, and the interpretation of the basic law by the MPCSC is the best solution to deal with the problem of babies born of mainland women in Hong Kong. And some members also mentioned the impending storm referred to by Justice Bokkary. Ms. Ursula might be a rather complicated personality. Now, if we look at current of previous quotations of Ms. Justice Bokkary, he described her as an unsung hero. And I've discussed with former officials of the Department of Justice. In private, they had every praise for the S4J then. Why? Because she was able to withstand pressure from Beijing. There might be things that CH Tong's team wanted to do, but she was able to withstand the pressure. But then she has made such remarks recently, perhaps prompted by Beijing. I believe she is very subservient to Beijing. Recently, I read this article from this magazine. Perhaps you've also read this because it circulated to every one of us. On the 29th of November last year, there was an interview report here, an interview of the previous head of the CPU, Professor Lau Shiu-kai, on One Country, Two Systems. And the interviewer said, well, it's been more than a decade. Professor Lau, what do you think of the implementation of One Country, Two Systems in Hong Kong? I think he was asking Professor Lau from Beijing's perspective. Professor Lau said that, well, in all these years, a lot has happened to the central authorities. The understanding of One Country, Two Systems in Hong Kong was a departure from Beijing's understanding. And for many of these things, they were not to Beijing's liking. For instance, some people did not respect the fact that Hong Kong has been returned to China, and then people's heart has not been united with the country, and even a relationship between the executive and the central authorities. Well, he said that there is a great discrepancy in thinking between people in Hong Kong and Beijing. And Professor Lau said that in the past decade or so, the central authorities' voices were not really in existence in Hong Kong, and their say has been taken away from them. And that's why there's been several rounds of interpretation of the basic law by the MPCSC. There were some departure from the original design, and there should be some renewed understanding. And there are issues with no consensus, and they are hard to tackle because there is not a common language. There are problems because the Democratic camp has chosen to interpret One Country, Two Systems, high level of autonomy, relationship between the SAR and the central authorities solely naturally. And this interpretation has been accepted by many people in Hong Kong. The idea is already deep-rooted, and it's difficult for the central authorities to turn around the people's thinking. No matter hard it is, Beijing is going to do something about it, and inevitably there might be interpretation of the basic law. Well, things might be rather unclear yet, but when there might be very strong confrontations or struggles if both parties are to be honest. Well, I think Professor Lau doesn't have a good understanding of the pro-democratic camp. Now, if the central authorities cannot act with restraint, now, if they would like to undermine the rule of law and One Country, Two Systems in Hong Kong, this is a lose-lose situation for both sides. We are not here for a revolution. We are not terrorists. But I disagreed with the saying that the central authorities have not pointed fingers at Hong Kong in recent years, but they have promised Hong Kong something. I hope they can think twice, and please do not damage this system which we took pains to establish. Thank you. Does any member wish to speak? Mr. Martin Liu? Thank you, President. I speak to support Mr. Dennis KWOK's original motion as well as the amendments by Mr. IP Kwok-him and Dr. Lo Wai-kwok. One country, two systems is something we should uphold. Without it, then we cannot have Hong Kong people ruling Hong Kong a high degree of autonomy as promised in the Basic Law. And we can't even have another 15 years of capitalism being practiced in Hong Kong and to maintain our way of life. However, there can be different understanding and interpretation of one country, two systems. So we must have a law to ensure the proper implementation of one country, two systems. So the Basic Law is our mini constitution and is the only legal safeguard we have for one country, two systems. Basic Law is different from the common law first. It is not a piece of legislation enacted by the legislature in Hong Kong. Rather, it was made by a national law made by the NPCSC under the Constitution, National Constitution, and it applies to the whole country. Now, I'd like to start my discussion with the rule of law. The rule of law is one of the important pillars to ensure social justice, and it should be upheld by any society that goes for equality and justice, and it's also our core values in Hong Kong. But if you ask a common citizen in Hong Kong what is meant by the rule of law, I don't think there are many who can give you an answer. Even if they can, the interpretation may be very different. Aristotle has the following to say about the rule of law, and that is a rule should govern. And his definition is that law is statute that should be complied with by everyone. I think what it says is something to hold on to. So the law and the rule of law cannot be separated. If the rule of law is the spirit, then the law itself is blood and flesh. Yes, we always take pride in the rule of law in Hong Kong. However, at the same time, the people who think that the interpretation power of the NPCSC of the Basic Law will undermine our rule of law. The Basic Law has endowed the NPCSC the power to interpret the Basic Law. In fact, Article 158 says that the power of interpretation of the Basic Law is vested with the Standing Committee of the NPC. This has been the power of interpretation already put in place with the beginning of the Central People's Government, and this is a legislative interpretation. This is different from judicial interpretation. I understand that the fundamentalists of the common law may not necessarily agree to this, and they may think that judicial interpretation of the law is superior to legislative interpretation. But I must say that this is stemmed from continental law, and can be traced all its way back to ancient Roman. It's not an invention of mainland China. In countries where there is every respect for the rule of law, people, they are exercising civil law, well, there is still legislative interpretation. Well, the UK can also allow its parliament to interpret explanatory law. I disagree that the power of interpretation by the NPCSC would undermine the rule of law in Hong Kong. First, Article 158 of the Basic Law empowers the NPCSC to interpret the Basic Law. This is part of the law as well as the part of the rule of law in Hong Kong. Secondly, in 1999, in Lau Kong Yung's case, it is confirmed that the power of NPCSC to interpret the Basic Law has stemmed from the Constitution, and there should not be any restrictions. So this is part of our law, and it's also part of the rule of law. Now, whether it is based on civil law or common law, the NPCSC does have the power interpretation of the Basic Law. Of course, nobody wants to seek interpretation of the law lightly, including the NPCSC. My position is it can only be done as a last resort to clarify the relevant legislative provisions, and that the relevant issues have profound and far-reaching implications on Hong Kong. Otherwise, we should not take this step lightly. However, I'd like to say that this is a political position rather than a legal position. My legal position is very clear. Interpretation of the Basic Law by NPCSC is fully constitutional and legal. Well, the CFA has yet to make a ruling on whether an application should be made to the NPCSC, and therefore we should not make remarks lightly, deliberately or otherwise, because that would influence the ruling and would undermine the rule of law. Regardless of our views, we should exercise self-restraint so that the court can make its decision in accordance with the law. Thank you. I so submit.
Does any other member wish to speak? Dr. Fernando Cheung. Thank you, Mr. Deputy. I rise to speak, of course, to support Mr. Dennis KWOK's original motion and safeguard our judicial independence and the spirit of the rule of law. As Mr. Bokhari has said, today we face a judicial storm. This storm threatens the independence of our judiciary, our judicial system. Can we maintain the separation of powers where we have checks and balances? This is right before us, and the change is going to occur right before us. Mr. Deputy, we know power tends to corrupt, and absolute power corrupts absolutely. Human civilization has developed to such a stage that we know that self-discipline is difficult. It's because of the good side and bad side of human nature. When we have a totalitarian regime, well, it would rise to high power and then go down. You may have good emperors and bad emperors, no matter what. Later rulers will certainly decline. That's why we want to have separation of powers. The three powers must be kept distinct and separate. This is an advanced feature of modern society. If there's no such separation, the community or the country concerned is not going to survive long. So it's important that we keep the system intact in Hong Kong. After the reunification, we know that we are under a totalitarian regime in China where they have no separation of powers. There are three powers cooperate with one another. It's a totalitarian government in China, and all the three powers serve the executive. The ruler, the party, has every power. They reign supreme all the time. But this system is so different from ours. We are much more advanced in so many aspects. And that's why we have the basic law, and that's why in the basic law we have to state very clearly that the power of final adjudication should be vested in the Court of Final Appeal in Hong Kong rather than in the central authorities. Of course, that's subject to certain restrictions. If it's a foreign affairs, national defense, or anything to do with the relationship between the central authorities and Hong Kong, they are not covered because we have to respect the sovereign. But anyway, in our system, we must maintain the separation of powers. After the reunification, yes, we can see in the basic law that the CPG has not been agreeable to give all the power to Hong Kong. So they still reserve the power of interpretation, and that power is to be exercised by the Standing Committee of the MPC. But this is something as a reserved power and cannot be invoked lightly. If you want to have separation of powers, so unless the subject matter is national defense or foreign affairs, then we must let our court be the authority for final adjudication. But if you say after your judgment, I can reinterpret the law, and then in future cases you have to deliver your judgments on the basis of my reinterpretation. So in that case, the Standing Committee of the MPC would be above everything else, and this would affect the rule of law. But this is the compromise. This is the only way to assure the central authorities. So we cannot avoid giving the interpretation power to the Standing Committee of MPC. Now this power has been exercised 4 times. Every time it dealt a blow to our system. The case of Ng Ling, the case of Chong Feng Yuen are all like that. And now, with this case involving foreign domestic helpers, Mr. Secretary for Justice, you are introducing a dangerous precedent, and you're asking the court to seek the views of the Standing Committee of MPC to see whether the views of the preparatory committee would represent part of the interpretation. So the preparatory committee's views came years after the implementation of the basic law, and now in a roundabout way, the views of the preparatory committee would become a part of the basic law. I'm not a legal expert, but we have to read the provisions. We should not just second guess the legislative intent. Of course, the preparatory committee has its own terms of reference to explain certain things. What if they talk about something else or something new, or 10 or 20 years down the road? What would happen? This is a dangerous move, and still you want to move in that direction. This will compromise the rule of law. And you would not even promise us that you would never seek interpretation if the court rule against you in relation to your requests. Back then, the S4J, the former F4J, agreed not to try to overrule the judgment of the Court of Final Appeal. So now you want to overrule the Chong Feng Yuen case judgment. You are slapping the judges on their faces. So are you not compromising the rule of law? So I submit. I support the original motion. Mr. Kenneth Leung, Mr. Deputy, thank you. I speak to support the motion moved by Mr. Dennis KWOK. I urge the government to safeguard the rule of law and judicial independence, to uphold one country, two systems as well. I would like to refer to the remarks made by Professor Dai Yiu-chung in a seminar as regards what is meant by rule of law, and that is that we must have laws that we all obey. And I'm not just talking about our citizens. The government must also obey the law, and on a higher level, there must be due and just process and system. And this just system must be there to uphold results which are just. But what is meant by just? Different legal experts may have different views or different definition. In the book A Theory of Justice, this author John Ross says justice is a basic social contract. Simply put, all sectors, all the parties, including the government, are parties to this contract, and everyone must abide by the contract. Say, in government, and the government in a totalitarian regime, country, if the government is not happy with the judgment handed down by a judge, what will happen to the judge? Well, the judge may disappear. I don't want to see this happen to Hong Kong. If we look at the power of interpretation, then Article 158 in Chapter 8 is the overriding article. The power of interpretation of this law shall be vested in the Standing Committee of the National People's Congress. If we expand this power indefinitely, then every article in the Basic Law can be interpreted by the Standing Committee of the NPC, because everything will be covered by Article 158. But the Central People's Government, after the signing of the Joint Declaration, to promise Hong Kong people one country, two systems. And the core system is that the exercise of sovereignty must be carried out with restraint, and the central authorities will not interfere with our judicial system. Of course, the Basic Law was enacted under the Constitution of the PRC in a civil law system. This is our mini constitution, and this is civil law. But in Hong Kong, we practice common law. So obviously, if you want to apply a system which is based on common law to a piece of legislation based on civil law, is going to be difficult and problematic. And therefore, our SAR governments and the Central People's Government must act with restraint. And our government, our SAR government, must obey the law. Mr. Martin Liu spoke on legislative interpretation and judicial interpretation under the common law. In some instances, we'll have to refer to the legislative intent in certain cases. But it's not like what Mr. Rumsky-Yun said, that we should refer to documents prepared by the preparatory committee. Mr. Yun, I think you remember that in your university lectures, there was a case, Pepper versus Hart, in 1992, which set out that in certain cases, in the case of ambiguities of the law, the court might refer to the Hansard document or the debate as recorded in the Hansard. If the legal provision is clear, the law must apply established rules in interpreting legal provisions. But of course, there are exceptions, and the exceptions must be dealt with or must be applied very carefully. And when you apply this rule, you have to look at the debate in Parliament. When you have an ambiguity or ambiguities, or the legal provision will lead to some certain absurdity, there must be such a situation whereby only then you can apply the exception. So why are you seeking the Standing Committee of MPC now, Secretary?
Door to the reception of material not readily or ordinarily accessible to the citizen, whose rights and duties are to be affected by the words in which the legislature has elected to express its will. You
are asking the CFA to seek an interpretation from the NPC, and you are saying that we should look at the source documents related to the enactment of the law. Then to the parties to the case, and that is the Filipino domestic helpers, is not fair, because these helpers, well, your time is up, so I submit.
Does any other member wish to speak? Mr. Abraham Shack.
This spate of wrangling about Hong Kong's judicial independence is looming, following the statement released by the Secretary for Justice on 13 December 2012, that the Secretary had made a request to the CFA under Article 153 of the Basic Law of HKSAR in the Foreign Domestic Helpers Final Appeals for seeking an interpretation from the Standing Committee of the National People's Congress, the Standing Committee, to clarify certain issues concerning the binding effect of the Standing Committee's 1999 interpretation of Articles 22(4) and 24(2) and 3 of the Basic Law, as well as the proper interpretation of the right of a vote for all categories of persons under Article 24(2), including foreign domestic helpers. Obviously, the Secretary's bold attempt to finally resolve the thorny issue of the right of a vote has touched on the sensitive nerves of those who treasure the rule of law and judicial independence. Our basic law has bestowed upon us the very new concept of one country, two systems, and the rule of law with the separation of powers with defined checks and balances. Despite the mastery stroke of our founding fathers in formulating and drafting the basic law, the success of this basic law for the present and the future rests with our faithfully complying to the words of the written law. It is not for those who are in authority to break this particular law and use the law for their own benefits. This is very important as a pillar of the rule of law. Every one of us in Hong Kong is free to express their support or disapproval of the Secretary's request to seek an interpretation from the Standing Committee or through the CFA. As freedom of speech and freedom of expression are protected by the Article 27 of the Basic Law and the Hong Kong Bills of Rights Ordinance. Nevertheless, freedom of expression is not without its limitation, nor its absolute concept. Honourable colleagues have spoken eloquently for and against the Secretary's request, both inside and outside this chamber. And the Honourable Gary Fang has even proposed an amendment urging the government not to seek an interpretation of the Basic Law. Many fear that all these statements amount to putting pressure on the Court of Final Appeal in its pending judgment on the case, and thus undermining judicial independence. In this respect, I take a different view, to the extent that for the last 15 years, our judiciary and our courts has weathered political tsunamis and storms and had stood tall. Their record makes us proud. In this respect, I call on honourable colleagues to read the statement of the Hong Kong Bar Association, released on 18th December 2012. While the Bar Association affirms in the statement that freedom of expression is cherished value of Hong Kong, it also states that freedom of expression is not to be valued above everything. The statement says, when the matter is sub judice, high-profile commentary and conjecture might be perceived to add unnecessary pressure to those concerned, and are best avoided, unquote. As explained by the Bar Association, the legitimacy of the Secretary request is beyond question. The Secretary for Justice has a professional and constitutional responsibility to advance on behalf of the government all agreements that he, his department and external counsel consider to be reasonably arguable, just as the counsel for every other party is obliged and expected to do so. In other words, it appeared that neither fair and reasonable to claim the Secretary for Justice has sabotaged judicial independence by making such a request. The question is, do you need to do that? And why should you do that? What is the motive for you to doing that? Are you taking yourself into making yourself in a position that you are above the law, or you're interpreting the law in a different way? This you have to answer, Mr. Secretary. Mr. President, the one country, two system is not a two separate concepts. It should be treated as an indivisible whole. It would be unrealistic to set up a dichotomy to disintegrate this concept. Admittedly, differences exist in legal system, among others, between the mainland and the Hong Kong. Under the principle of one country, two system, the legal framework of Hong Kong is based on the English common law, supplemented by local legislation in contrast. The legal system of the People's Republic of China is akin to a system in continental Europe and in order to make the two systems legal work in concert, Article 158 of the Basic Law is the key to bridging the gap. The question again lies in the way of how and when it should be used, and should not be used blatantly. Nevertheless, there is fear that this very key could unlock a Pandora box of excessive interference with court decisions and hence sabotage Hong Kong judicial independence. This fear, which is based on our premise that the authority will exercise such power willy-nilly for political expediency or whatever it sees fit. Politically right might not be, politically good might not be right in terms of judicial independence. Think before you act. Thank you.
仲有冇其他議員要發言？
Does any other member wish to speak? Mr. Leung Kwok-him? Mr. Deputy. This is actually a very simple matter. I think they're just playing an underhanded trick, playing foul, hitting under the belt, like in a ball game. You are a lawyer, Secretary, but you are part of the administration. You represent the executive. And in a litigation, you ask the court to seek an interpretation. Under Article 158, you may seek an interpretation from the NPCSC. And let me remind you that before you make a final decision, if there is anything unclear, you should seek interpretation from the NPCSC. And then you added something that is unrelated in relation to the Filipino domestic helpers. It is not about the interpretation of the entire section of the law. I said it's an underhanded trick. You represent the administration. Of course, there are a number of occasions of interpretation, one done by Mr. Tong Chi-wa. One time it was a letter was written to the State Council asking for an interpretation. On this occasion, it is a move by the S4J, because you are the lawyer representing the administration in the court of law. You are a lawyer, and at the same time, you're a government official. So it's really puzzling. If you ask the court to seek interpretation of related issues before there is a final ruling, well, this is not appropriate because the case doesn't touch on other issues. If we're only talking about rights of abode of Filipino domestic helpers, then you only need to interpret part of the legislation, not all. But if you say to me that, well, I just want to do it in one go instead of piece by piece so that I will not be reprimanded by you, Mr. Leung Kwok-him, then I would understand. And if you want to tackle babies born to mainland women with no Hong Kong ties, well, then that is not the way to do it. You are just hitting under the belt. When I'm playing the ball game, you can't change the rule of the game halfway through. I was playing football. If halfway through you say, well, it's the rule of handball that apply, then I will be puzzled. If you ask to amend the basic law, then it's very clear. Because Article 158 is about interpretation, 159 is about amendment to the basic law. It is, and there are statute laws who states how it should be done, and the council plays a role. Mr. Martin Liao will have a play to role because you need 2/3, so it's very prudent. When it comes to an amendment, there is no retrospective effect. You don't know when the amendment will be made to the law. But when it comes to interpretation, that is completely different because it's a whole different matter. People, there will be doubts. With your approach, you may say that, well, the judges in the past have made a mistake, and now we need to correct it by seeking an interpretation. If that is the case, then you will have to inform every single one that you have used underhanded trick to. Say, for example, mainland babies born to mainland women with no Hong Kong ties. You will have to find each and every one of them to ask them if they would like to speak in the court. Interpretation and amendment to the law are two different systems, and they have two completely different political meanings with different consequences. You will have to explain to the council and to explain to everyone who are involved in cases who are affected by your request to the CFA for an interpretation. You will have to inform them, asking them if they would like legal aid. Otherwise, once the chance passes, there is no turning back. Well, I wanted to scold you on the day when I was attending Mr. Ronnie Tong's banquet, but that wasn't appropriate, so I did not do it. I hope you will speak to your counterparts on the mainland, telling them that this is not the way to go. Amendment to the basic law is something huge, and we've been reminded constantly that we should not take it lightly. Yes, there are checks and balances, And you can't say that since it is a major move to amend the basic law, let's have the basic law interpreted. And you are forcing the court to do it. Well, I don't know whether the judges will listen to you. And in fact, you are challenging them. Or you may adopt Tong Chi-wa's approach. Or, at an extreme, ask Leung Kwok-him to write to them. For Article 158, you say that there is a citizen in Hong Kong, Mr. Leung Kwok-him, who don't like this at all, and he wants an interpretation from the NPCSC. Well, we don't have to do it this way. You can ask Leung Kwok-him, Claudia Mo, Aileen Leung, or the president to write a letter to them asking for an interpretation. That's why I asked you not to do so much. That's why I was so angry that I wanted to go and dress you down. But I did not want to do so because that they will not be pleasant. I just hope that you will not do it.
Ms. Sit Ho. Thank you, Mr. Deputy. Hong Kong, how is Hong Kong different from other cities of the rest of China? What makes Hong Kong different? And why are we not just like any other city of the mainland? It's true that we don't have democracy, and this legislature cannot represent the people of Hong Kong 100%. Still, in Hong Kong, we have the Common Law Convention. We have a legal system that can protect our rights and freedoms, and therefore residents of Hong Kong have greater safeguards than their counterparts on the mainland. We need not fear about prisons that would torture you, which kept Mr. Li Huangyang. You don't have to worry that our prayers will be like the press on the mainland. If Wan Qiu Shibao daily on the mainland doesn't cover the criticism against the Nanfang Shibao Zhao Mo incident, it will be censored. Well, even in Hong Kong, we will only be taken away. Might have some restrictions, but still, it is the beauty of having the rule of law in Hong Kong. Well, when Justice Bakari retired, he made a few remarks, and there are some not yet quoted by members, and I must repeat them to put on record what he said. He said that you cannot dismantle freedom of the press. Well, you cannot separate a freedom from press. Without the press, without a free press, you don't have real freedom. Without freedom, you won't have a free press, and that's what's happening on the mainland. Without freedom of the press, there is no justice. And Justice Bakari also said that you cannot separate the judiciary and independence, because without independence, the judiciary will be meaningless. So I'm very grateful to Mr. Dennis KWOK for moving this motion. Of course, there are still things wanting in this motion. The one country, two system is not just about the rule of law. Still, I hope we can safeguard the rule of law and judicial independence in Hong Kong so that we can protect freedoms and rights of Hong Kong people. At least we will still be very different from other cities of the mainland. It is because of our judicial independence that we can be a world financial center. Many foreign investors and many investors or bankers who were born on the mainland, said in Hong Kong that it will be a long time before Shanghai can catch up with us, unless they have a proper legal system and judicial independence. They won't be able to replace Hong Kong. So, so long as we have an independent judiciary, investors are still confident that their disputes can be properly settled in Hong Kong. And the rule of law is not just about an independent judiciary. It's also about whether our senior officials exercise self-restraint, or whether they are law-abiding, or whether they take the lead to break the law. Yesterday, we had so many hours of debate on Mr. C.Y. Leung's conduct. He violated the law, and he used public money. He used his CE elect office to issue statements that were far from true. So he put himself above the law. So even though our judiciary is independent, the Buildings Department dare not issue a summons to him. No one dares to charge the CE, and so the judiciary can only deal with cases put in front of it. But there are many cases of injustice in society. The judiciary is limited in its powers. He cannot be like Judge Pao, an ancient judge of China. The judiciary cannot initiate investigations and charge people. So just the rule of law is not enough. Senior officials must take the lead to respect the law. And our judiciary, when hearing cases, must exercise or this legislature in vetting legislation must have regard for natural justice. We cannot just accept anything put in front of us by the executive. We should not allow these unjust provisions to become a part of our law and then force our judges to make rulings according to such legislation. And then the last foothold we have is our civil society and the people of Hong Kong. We cannot rely on the police to keep an eye on everybody to ensure that they are law-abiding and to ensure that they will not break the law when no one is looking. Just like Ms. Sylvia Kao, a new member of the CPU crossed the double line. Of course, she said that she made an inadvertent mistake, but if not for the exposure by the media, she would not have handed herself in to the police. So whether we can continue to have the rule of law depends a lot on the civic society. The civic society will have to monitor our senior officials each and every minute. So even if they have just made a minor offense, such as crossing the double line, overtaking another kind of double line, it should be exposed so that we continue to have the rule of law. Does any other member wish to speak? If not, Mr. Dennis KWOK, Dr. Priscilla Leung. Will members who wish to speak please press the button. Thank you, President. I don't think anyone here would object to Mr. Dennis KWOK's motion. I think we are just talk about how we can express it better. Well, when we talked about the one country, two systems and the rule of law, we must start from common law and basic law. So something is wanting if there is no mention of basic law in the original motion, because the basic law is the basis for one country, two systems. Is the embodiment of one country, two systems, which is the outcome of Sino-British talks. It's just like a mixed child with is carrying both genes of the mother and the father. So there are many arguments, or there are many issues involving the basic law, all because of this. If you look at today's issues, well, both Justice Bakary and Miss Elsie Leung referred to previous cases. If you look at the times, in 1985 to 1990, when the basic law was being drafted, well, I think there were similar arguments between Britain and China back then. All right, everything is so politicized nowadays. Even legal issues are politicized. It's because the passage and making nature of the basic law has similar characteristics. This is because of its duality. Now, people may say that our society is very split. I would not use such a description. It's okay for two different systems to have clashes. It's not really a division. We need not be that negative. We need not say that because our views are miles apart, this is a storm. In the U.S., some academics have considered the various disputes since the announcement of its establishment of its constitution. There have been arguments for more than 50 years. Well, I think even for the members of the drafting committee, there are various controversies. There is autonomy, high level of autonomy. It is actually an expediency or a compromise of sovereignty, autonomy, and also status quo. Well, the Basic Law is a national law, but it's not just an ordinary national law. When the Basic Law was drafted, it was clear that both systems should be protected, so that this is a special law under different from other national laws. Other national laws cannot be like the Basic Law, which only applies to Hong Kong with the exception of Annex 3. So the Basic Law is an important rule of game for us in Hong Kong. The Basic Law is also the Constitution, the supreme law in Hong Kong. Article 8 says that the common law rules of equity, so on and so forth, shall be maintained, except for any that contravene the Basic Law. So the Basic Law has always been regarded as our mini constitution. From a historical point of view, Hong Kong was a British colony for 150 years. We have a lot of legacy from the common law. We're used to it. All right, Article 8 is valid, and Article 80 to 85 are also valid. In fact, when these articles were made, there was consensus between members of the drafting committee on both sides that common law judges and local judges from common law judges from other jurisdictions and from Hong Kong can preside cases together. But what about Articles 17, 18, and 158? And Mr. Leung Kwok-him said that Article 158 was excellent. I think he should read these articles more clearly. They are really not a common law convention or tradition. Really, it has this special duality. Now, 159. We all think that it is a panacea by amending the Basic Law. But if you look at it clearly, the power of amending this law shall be vested in the NPC, and there are three parties that can initiate this. First, NPC, second, State Council, third, the Hong Kong SAR. And if it's only when Hong Kong SAR proposes amendments to the law that we need a two-thirds support of this council. Well, is Article 159 the panacea? I don't think so. The Basic Law itself, well, looking back after 15 years. Now, we talked about Article 82. Many experts are not happy. Why should common law judges from other jurisdictions be allowed to hear cases in Hong Kong? Now, we don't like Article 158 here. Why should NPCSC be allowed to interpret the Basic Law? Because this was a compromise. There must be compromise between the two countries. Otherwise, we won't have one country, two systems. Now, if parents are skeptical of what their spouse proposes, then it will be bad for their child. Now, of course, both parties don't think that the basic law is perfect. It is a compromise to ensure that we have two systems in Hong Kong. Rather, it was made with a good intention. We should look at the merits of the cases. Well, both parties of the litigation, including the government, will have to win the case by using their powers allowed in the Constitution, and that is the power to seek interpretation. Chang Feng Yun and Mkaling cases, in these cases, the common law was adopted. Thank you.
Mr. Paul Chair, well, as the Chinese saying goes, for all families, they all got their own difficulties. So for Hong Kong, in relation to babies born in Hong Kong to mainland pregnant women and foreign domestic helpers right on the boat, we have been trying ways to uphold the rule of law while safeguarding our long-term future. Our previous sovereign state and also the birthplace of common law is facing an equally difficult question, if not more difficult than ours, and it's the right to vote by prisoners. Well, there are so many hurdles before we can amend the basic law. So should we go for interpretation or go for amendment? Equally, although although Parliament in England is supreme, they can amend the law, but they have a problem before them. And that is whether they should allow their prisoners to vote, although they have a piece of legislation, the Forfeiture Act, whereby the right to vote of prisoners has been forfeited. But because of a case in March 2004, the European Court of Human Rights ruled that the English law violates the Convention of Human Rights of Europe. And the jurisdiction rests with the European Court of Human Rights. And then Parliament wants to amend the law to the fact that what is not allowed by the European Court will be allowed. In February 2011, the lower house passed a law to maintain the forfeiture. The voting record is at 234 for and 34 against, or 22 against. So it was a big majority that prisoners should not be given or be given the rule of law. So what do you mean by rule of law here? When we talk about individual cases, rights of individuals, we can understand the situation clearly. Say it's a criminal law, it's a civil, a criminal litigation, a civil litigation, is something about the rights inter se and not about general rights. Then it's easier. But if we look at more general issues, whether abortion should be allowed, discrimination should be suffered, then it's not just about law itself, but sometimes it's a mixture of law and politics, or whether politics should be given more emphasis. If we adopt a fundamentalist perspective and regard the issues as legal in nature only, it's really naive, because that's not what people have been doing over the ages. We are not going to, we should not adopt this fundamentalist view. As Mr. Martin Liu has put it so nicely, I don't think judges or some fundamentalists can understand the point. We have continental law and common law. It's a mixture here. especially when it comes to the interaction between the mainland and Hong Kong. Under the civil law system, it's not just about looking up the precedents or the statutes. The process of legislation, the legislative intent, and also social consequence or impact will be looked into. And the legislative intent is not just about referring to documents before the enactment or the discussion in the legislature. Subsequent phenomenon or social phenomena subsequent to the enactment will also be looked into. We should not be too restrictive about ourselves. Otherwise, we're just barking up the wrong tree. Mr. Leung Kok-him is a member who has been involved in relatively more litigations. But I have been involved in some. In terms of quality, it's by no means less substantial. I have been involved in 2.5 litigations, the half meaning that the request to proceed was turned down. Sometimes the principles will be amended not through legislature, but through the judgment of the 3 judges or 5 judges. This is the so-called landmark decision. So suddenly, the change took place. If you say everyone should be allowed a say or hearing, you don't understand the law. Before Donoghue and Stevenson, people are so concerned about duty of care. And everyone, there's a landmark decision. A lot of people will be affected by the decision. If we want to give a chance to be heard to everyone potentially affected, that would be ridiculous. That shows the proponent that doesn't understand the system. This time, the Secretary for Justice is a party to the litigation. If he wants to remind the Court of Final Appeal that this is the route open to the court, this is reasonable and legal. And I think we should understand his request as such. Mr. Alan Leung, if someone wants me to define the rule of law, I can be very simple and straightforward. Rule of law means that we are people-oriented. We respect everyone's rights. And we uphold and protect a democratic system. Such a definition is easy to understand. After the reunification, some people have been trying to target the rule of law, and that's also easy to understand. If you adopt my definition, and you think laws are impeding executive efficiency, or on the mainland where Marxism and Leninism and Maoism are the practice, law is just a tool for the ruler. There's no need to dispute this. It's clearly set out in all the literature on Marxism, Leninism, and Maoism. This motion moved by Mr. Dennis KWOK is very timely. Well, after the reunifications, let's just see a number of landmark cases. Article 23 legislation, the IPO of the link, the Dan C.E., Mr. C.H. Tong, and Mr. Henry Tang was the financial secretary. He asked the Court of Final Appeal to get it done quickly and deal with the litigation brought by Madam Lo Lam. But the Chief Justice had a lot of integrity. He said Madam Lo should not be rushed, and time should be allowed for him to prepare. And on the 6th of October, Mrs. Elsie Leung used terms such as ridding Hong Kong of Chinese characteristics and so on and so forth. It's terms she seldom used. And then there are other people saying that if you are not Chinese national, you should not be a court of final appeal. And then Mr. Zhang Xiaoming, the current head of the liaison office, and he said that the NPC should consider how to improve the supervisory role in terms of legislation from Hong Kong. If they do not want to uphold, if they do not want to impact on the rule of law or the judicial independence, so much the better. But we must be vigilant whether this is a prelude to the coming challenges to our system. And vigilance is never a bad thing. So, according to some members, you people are the legal fundamentalists. That's why you object to interpretation. Let me state this clearly. Mr. President, I can read the basic law. I know how to read the basic law. Mr. Martin Neal said this is a political matter. We have different political judgment. I respect his views. In terms of law, in terms of constitution, I accept that the Standing Committee of the NPC has the power to interpret the basic law. If I haven't made myself clear previously, I would like to do it now. This supreme body, the Standing Committee of NPC, under the new, at the beginning, if it started to interpret laws at the beginning of the new constitutional order, how can we establish the constitutional order under one country, two systems? This is the political judgment if they keep on interpreting laws or provisions in the basic law. Because the political judgment, as I see it, would say that we should not interpret the basic law frequently. Mr. Leung Kong is right that you are flouting the rules. Whether we're talking about the case of Unkaling, where the government stated certain position in those cases. When the CJ, Mr. Justice Lee, asked Mr. Fook Siu Kong, counsel for the government, what the government's position was, or whether there was any precedent decision or interpretation made by the NPC which will have bearing on this court's judgment. The answer was no. So the court just applied common law. And after that, Mr. Qiao Xiaoyang, the Secretary General of the Standing Commission, saying that the Court of Final Appeals judgment was not entirely consistent with the interpretation of the SC of NPC in Chong Fong Yun case. And Mrs. Regina Yip, the then Secretary for Security, said that no further action will be taken in respect of Chong Fong Yun case. 12 years later, 12 years down the road. And now you want to ask the Court of Final Appeal to rectify its own decision. You are asking the court to slap itself on its face. Wouldn't this affect the authority of the CFA by putting in such a request? Some members have said that we should respect the judicial independence. We should keep our mouth shut. Our Secretary for Justice is the guardian of our judicial independence. Now, 12 years after the case, he makes such a request. I want him to withdraw that request. Of course, I'm confident that the judges can withstand such pressures brought by the request of the SOJ, but it's just that they should withdraw the request. I hope this motion can be supported by the whole Council. Otherwise, we'll be sending a very alarming signal out indeed.
Mr. Chen Chi-chun, I have been thinking a lot about whether to speak or not. The motion moved by Mr. Dennis KWOK is to ask the administration to safeguard the rule of law and judicial independence. To put it colloquially, it is the motion that states that the Pope is Catholic. Well, it's just like asking Hong Kong people to take care of themselves. Today is 2013. This motion is to teach the administration something that is commonly known, that you should take care of your good health, say, for example, to remind them to safeguard the rule of law and judicial independence. Someone said that Confucius keeps talking about filial duty. Jesus talks about being benevolent, and it's because both of them see that human beings are the worst example of being filial and benevolent. That's why they keep talking about it. And I think that what's happening today is that legislators are afraid that the administration will completely flout the law and ignore the rule of law. People are unhappy about their lives, and CY Leung has done a lot, but he can't blame that the financial turmoil like Tong Chi Wa. So I would like to ask the administration if they know what Hong Kong people want, and they just want to copy and paste the communist way to Hong Kong. Before I talk about CY Leung's destruction of one country, two system, I would like to talk about the one country, two system. Loyalists have spoken about it. They say that one country overrides two system because they've heard it from somewhere. And they say that one country is above two systems. They don't understand. Deng Xiaoping said, when Deng Xiaoping said one country, two systems, he also said that the river water will not interfere with the water in the well. And I think what is happening now is that damaging our independence. Judicial independence. Hong Kong have our own system, and Hong Kong has a system because it's a society, because it has a special historical background. And the one country is about the system of the country as a whole, whereas the two systems is a system of a society. And if you want to turn into a country, then there will be an adversarial role. And if there is one country, two system, if you stay as a city, then there will be no adversary role. And it's just talk about the relative position of the two. In 1982, Deng Xiaoping explained about the one country, two system. He said that the concept, the implementation of the concept is that the livelihood, the ways of life, and financial system, the free port, and rule of law will remain unchanged. Well, the sending of the Liberation Army here is to make sure that Hong Kong will stay safe. It's about national defense. Last month, CY Leung went to Beijing to see the state leaders. I think CY Leung should be ashamed because he's been playing a lot of dirty tricks. He wouldn't think. Well, he said that Deng Xiaoping should be a Nobel Prize laureate, but he did not know what exactly Deng said. He wanted to pretend that he has his own mind and he had the ability to govern Hong Kong. And at the same time, by going to the liaison office, he showed that he succumbed to the liaison office. And when he's taken office, he wanted Anthony Kwok-him to roll out the national studies. This in turn undermines and destroys the way that Hong Kong's way of life should remain unchanged. And then he changed the nature of the Central Policy Unit. He changed the system. He wanted to put in more people with a red background, so that there will be a team working for him. He changed the system. He has damaged the internal system of Hong Kong, and I don't think you will forget that recently. Well, Justice Kamal Bukhari said that there are clouds heralding a storm of unprecedented ferocity, and I think that this is coming true. The Secretary for Justice made a request to the CFA asking for an interpretation together with the provisions related to immigration policies or that has something to do with the babies born to pregnant women with no Hong Kong ties. And I think it's completely flouted the rule of law. In the New Year's Day march, it was an orderly march, and however they have changed, they have talked about a completely different story. And protesters were accused of illegally assembly when the police have not done what they're supposed to. I think this is the darkest day of the rule of law in Hong Kong. There were wanton arrests, and there are a number of people being arrested on the 1st of July 2011, and 4 people went to trial. And the cases have been dragging on for quite a long time. Tomorrow I had to attend court hearing. Still today we're talking about something that is so well known. I think this is a damage to the rule of law and completely flout the spirit of the rule of law. What can Hong Kong people do in the end? I think we all know. I hope all legislators will support this motion that states the obvious, that people should take care of themselves. And even if this motion is carried, it doesn't mean that our rule of law and the one country two system can be preserved or maintained. Does any other member wish to speak?
Mr. Dennis KWOK, you might now speak on the amendments. Thank you, President. Mr. LO Wai-kwok and Mr. Jeffrey Lam said that the one country two systems is here because the central authorities have authorized that Hong Kong have autonomy. Now, this is not really authorization, rather a contract. It's a contract between the central authorities and also Hong Kong people. It is constitutionally binding. For this contract to continue to be valid, the central authorities must accept self-restraint and self-monitoring. Now, if the central authorities would continue to enlarge its power indefinitely, then the contract will be null and void. Mr. LO Wai-kwok said that for the past 4 rounds of interpretations, they were necessary and appropriate and perfectly legitimate. Well, the SPJ here, I believe Mr. Rimsky, the SPJ, I know, will not agree to such remarks. Mr. IP Kwok-him said that we must comply with the law. He mentioned 2 times that we must act in accordance with the law. Sticking to the law is an important concept of the rule of law, but I think it's only half true, because this is just a very elementary idea of the rule of law. Well, even in general studies teaching material of the second of primary school, we have 2 levels. First, there must be a rule to comply with, and there must be the rule of law. Now, the rule of law is about using the law to restrict or to confine the power of the authorities. And I think he has missed out the most important concept or most important bit of the rule of law. If he wants to understand it better, I think he can refer to the teaching materials of primary and secondary schools, and I would be more than happy to answer whatever questions he has. President, many members refer to the question of seeking an interpretation. Now, Mr. Kwok, these 5 minutes are for you to speak on the 4 amendments. Yes, because the amendments, well, the wording of the amendments are very simple. I want to reserve it to the very end, but you will still have time to respond to the remarks of members later. Regarding the amendment of Mr. Kwok-him and other members, well, regarding the 2 words, continue to, and also further amendments by Mr. Tam Yiu-chung to Mr. LO Wai-kwok's amendment are unnecessary because the original motion has put down, set out very succinctly the crux of our motion. Mr. Martin Liu and Dr. Priscilla Long talked about interpretation of the basic law by the NPCSC. I think they have to accept 2 facts. Our one major difference between the legal system we have here and the mainland is not just that they have they exercise civil law and we exercise common law. Rather, our legal system is better and superior to what they have on the mainland. This is a fact that we have to admit and accept. And most important of all, they have political procedures rather than political proceedings rather than judicial proceedings. This is the crux of the matter. Now, if you want to say that in jurisdiction practicing civil law, they also have procedures for seeking legal interpretation, then you have totally disregarded the difference in the legal system of the 2 sides. This is not just about a difference in the system, but a difference in value. Chairman. My motion hopes that we can use the credibility of this council to let people know that we do respect the rule of law, the legal system, judicial independence, and will continue to uphold 1 country, 2 systems.
The Secretary for Justice. President, I would like to thank members for their views. I'm not going to respond to views not directly related to the motion. I want to stress this point. In my opening speech, I already referred to the system under the basic law and how we can safeguard our rule of law, our judicial independence, and also referred to the branch opened in Hong Kong by the Hague Judicial Organization, and that's a vote of confidence in Hong Kong. Some people have doubted our achievement in the field of rule of law, or whether there will be a crisis coming our way. Maybe I can share with you the piece of information that you may already know, and that is today the Wall Street Journal and the Heritage Foundations announced is a freedom index, and we are still the freest economy in the world. And in terms of rule of law, we still have a score of more than 90. Our legal system, our judicial independence, and other legal related systems have all got the recognition and support from the international community. Some members query why we want to seek interpretation, whether there is a political motive there. Mr. Tom said seeking an interpretation itself may not compromise the rule of law, but it should not be done if there's a political motive. Mr. Leung Kok-hong says we are flouting the rules. We are not playing by the rules. Mr. Shed says that although procedurally this can be done, the question of the matter is why. Why would we like to have it done? Perhaps I can respond to these views in one go. The answer to this question is simple. This time, the subject matter, it's a case involving foreign domestic helpers and other cases involving the right of abode. although you may say that it has to do with our own population policy or a question of our economic development. But at the end of the day, we cannot deny that this is an out-and-out legal issue. A legal issue cannot be completely resolved through administrative means. Through the news, the media, and other sources, we know that if we want to resolve a legal problem through administrative means, then there's a risk that it cannot be handled properly. Since this is a legal issue, as a responsible government, the only appropriate way forward for the government is to follow the well-established legal system in Hong Kong to resolve this legal issue. As I've said in my opening speech, Article 185(3) of the Basic Law is part of our constitutional setup. We have this case in the Court of Final Appeal. This is a case in our legal system, a court case in our legal system. Therefore, relying on Article 158(3), we would like to make use of the judicial system, our own system, to resolve an important legal issue of ours. It's not just appropriate. It's something that a responsible government should do. Whether it's there's a political reason, or whether we are trying to twist the rules. Let me respond by referring to this position. The court case involving foreign domestic helpers in its final stage. In the court of first instance, Mr. Justice Lam, at that time, the government already stated very clearly that it will reserve this right to take the action that we are now doing. That's clearly recorded in the judgment delivered by Mr. Justice Lam. In the Court of Appeal, again, the government's representative, the representative from the DOJ, also expressly reserved this right in the Court of Appeals case. So we are doing this by exercising the reserve right. And in the Court of Appeal case, again, Mr. Justice Chung asked whether the 1999 interpretation would be binding on Hong Kong courts, because the parties to the case did not advance any arguments in favor or against it. So the court regarded this as open issue. So we believe this is reasonable and just to go down this route or this approach be adopted. I think one of the important principles under the rule of law is that the government should be bound by our laws. But we should take one further step, and that is in a court case, the government should also enjoy certain rights. As some members have read out, the Bar Association has stated very clearly, as a party to the case, the government has the right or has the constitutional responsibility to raise this issue with the court. Lastly, with regard to the request, whether it's right or wrong for us to make the request is not up to me or up to any member or all members collectively. The only one who can decide whether my request is right or not, it would be the judges of the Court of Final Appeal, having heard the arguments from counsel or from both sides. So there's no political motive to speak of. This is a pure court case. As Mr. Leung has put it, we should not politicize a legal issue. We should not try to twist or skirt the rules. We are doing what we should do under the rules and procedures in our legal system. A number of members refer to Ms. Elsie Leung's speech. I don't want to say any more about this because previously in another panel meeting of the panel, we have expressed our views, and I don't need to repeat those views. All in all, in seeking or in putting forth the request for interpretation, we have no intention to pressurize the court or to affect the rule of law. We are determined to uphold one country, two systems, judicial independence, and the basic law. With regard to the motion and the amendments moved by some members, well, we would like members to support the amendments moved by Dr. LO Wai-kwok, Mr. IP Kwok-him, and Mr. TAM Yiu-chung. And I hope members would oppose to the amendment moved by Mr. Gary Fan. So I submit, Mr. President.
I now call upon Dr. LO Wai-kwok to move the amendment for the motion. Dr. Wai-kwok, President, I move that the Honorable Dennis KWOK's motion be amended. And I propose the question, and that is that the amendment moved by Dr. LO Wai-kwok to Mr. Dennis KWOK's motion be passed. I now call upon Mr. TAM Yiu-chung to move the amendment to Dr. LO Wai-kwok's amendment. Mr. TAM Yiu-chung, President, I move that Dr. LO Wai-kwok's amendment be amended. And I propose the question to you, and that is that the amendment moved by Mr. TAM Yiu-chung to Dr. LO Wai-kwok's amendment be passed. And I'll put the question to you as stated. Would those in favor please raise their hands? Those against, please raise their hands. I think Mr. Wong Yuk-man claims a division. The division bell will ring for 5 minutes.
開始表決。
Voting begins.
請各位核對所作表。
Please check your votes. If there are no questions, voting is closed. The results are displayed. Members from FCs, 28 present, 20 against, 0 abstention. Members from GCs, 26 present, 16 against, 0 abstention. The question is not agreed the majority respective of each of the two groups of members present. I declare the amendment negative. Mr. Andrew Leung. President, I move that in the event of further divisions being claimed at this meeting, motion in respect of the motion for safeguarding rule of law, this council shall proceed forthwith to the division after the division has been rung for 1 minute. I now propose the question, and that is the motion moved by Mr. Andrew Leung be passed. Does any member wish to speak? I now put a question to the vote. Will those in favor please raise their hands? Those against please raise their hands. I think the question is agreed by majority respective of each of the two groups of members, that is those returned by FCs and those returned by GCs who are present. I declare the motion passed. I direct that in the event of further divisions being claimed at this meeting in respect of the motion on safeguarding the rule of law, this council shall proceed forthwith to the division back after the bell has been rung for 1 minute. I now put a question, and that is that Mr. Kok Wai's amendment to Mr. Dennis KWOK's motion be passed. Will those in favor please raise their hands? Those against please raise their hands. Mr. James Toh claims the division. The division bell will ring for 1 minute.
開始表決。
Voting begins. Members, please check your votes. If there are no questions, voting is closed. The results are displayed. Members returned from FCs, 28 present, 8 against, 0 abstention. Members returned from GCs, 26 present, 9 against, 16 against, 0 abstention. The question is not agreed by a majority of respective each of the two groups of members present. I declare the amendment negative. Mr. IP Kwok-him, you may now move your amendment. I move that Mr. Dennis KWOK's motion be amended. I now put a question to you, and that is that amendment moved by Mr. Kwok-him to Mr. Dennis KWOK's motion be passed. And I put a question to you as stated. Will those in favor please raise their hands? Those against, please raise their hands. Ms. Seminole claims a division. The division bell will ring for 1 minute.
開始表決。
Voting begins. Members, please check your votes. If there are no questions, voting is closed. The results are displayed. Members returned from FCs, 28 present, 24 8 against, 0 abstention. Members returned from GCs, 26 present, 9 4 16 against, 0 abstention. The question is not agreed by majority respective of each of the two groups of members present. I declare the amendment negative. Mr. Gary Fan, you will now move your amendment. Personally, I move that Mr. Dennis KWOK's motion be amended. And I propose the question here, and that is that amendment moved by Mr. Gary Fan to Mr. Dennis KWOK's motion be passed. And I put a question to you as stated. Will those in favor please raise their hands? Those against, please raise their hands. I think Mr. Kwok-him claims the division. The division bell will ring for 1 minute. Voting begins. Members, please check your votes. If there are no questions, voting is closed. The results are displayed. Members returned from FCs, 28 present, 7 4 20 against, 1 abstention. Members returned from GCs, 27 present, 11 4 9 against, 6 abstentions. The question is not agreed by majority respective of each of the two groups of members present. I declare the amendment negative. Mr. Dennis KWOK, you may reply. You have 4 minutes, 6 seconds to reply. President, in his reply, the SVJ said that Hong Kong was still rated the freest economy in the world by the Heritage Foundation, and that we are #1 in terms of the openness of our society. But how about our country? It ranked is 136th in this year, and according to the Heritage Foundation,
to political influence and Communist Party directives. The party's ultimate authority throughout the economic system undermines the rule of law and respect for contracts. 引述完畢。主席，我諗講來講去，其實
unquote. Well, the ranking of the Heritage Foundation is one of the crux of our debate today. We are on top of the list. We are ranked the first. And when the CFJ is hearing a case, and all of a sudden you're asked to, why don't you go to ask not the judiciary but the legislature, a political legislature of a country who is at the bottom of the list, to help you to interpret the law, to help you to hear the case. The damage to our rule of law is imaginable. Well, we are #1 in class when it comes to the rule of law, and we are asked to invite someone who comes last in the class in the rule of law to interpret the law for us, to help our courts to rule in cases, regardless of what other members said, or whether there is this process of interpretation of the law in other civil law jurisdictions is all because that the spirit of the rule of law on the mainland is still very weak and fragile. If at this stage we ask them to interpret the basic law for us, this is a blow to our legal system and our judiciary. The SVJ said that they've acted in accordance with the law in any lawsuit. You are entitled to ask the court to make such an application. Yes, you might be entitled to do so. But when you advance such an argument, well, your capacity or status is very different from private parties to a lawsuit because you are the government. In this very important case, if you take such a move, you will cause a lot of political and constitutional issues and repercussions. So when you advance these arguments, you should not just think about whether the administration will win or lose in this court, but also whether the whole community, the whole community would win or lose in this case. And I'll put a question to you, and that is the motion moved by Mr. Dennis KWOK be passed. Will those in favor please raise their hands? Those against please place their hands. Mr. Kwok-him claims a division. The division bell will ring for 1 minute. Voting begins. Members, please check your votes. If there are no questions, voting is closed. The results are displayed. Members returned from FCs, 27 present, 11 for, 0 against, 16 abstentions. Members returned from GCs, 26 present, 19 for, 0 against, 6 abstentions. The questions are agreed of a majority respective of each of the two groups of members present. I declare the motion negative. I now adjourn the Council until 11 a.m. on Wednesday, the 16th of January 2013.